requires some more time. So let the matter comes after a week.
Okay. Item 13.
Item 13.
Okay. Item 13, you write Miss S. Miss Swati, what do you write? Forgot. Uh-huh.
Swati B. Baru.
Swati B. Borwa, learned counsel for the petitioner, prays for prays for an accommodation. The prayer is allowed. List this matter when 10 and 11 goes together.
After a week.
You're saying
day,
about
any day.
11, right?
11.
10 also goes.
Yes, 10. So then 10 will be fine.
Okay. So when do you want? 10th of June. 10th of June is coming Wednesday. Okay. 10th of June.
DPL.
May I please?
Yes.
With the consent of other side, Lordship, I beg to mention item number 24.
24.
Upon 26. Here I awaiting instruction. Content,
24 and
Lordship.
26.
Only 24.
Only 24. Content case.
Lordship.
2026.
Lordship, it is the fifth time, Lordship. They have sought time for to take instruction, Lordship. If they are not interested
On
to give
20.
instruction, then Lordship may kindly call for personal appearance of the condemned.
Okay, for the last opportunity, I'm giving him time. If on the next date he doesn't bring, we will see. Mr. S.S. Roy, learned counsel for the
Sole
respondent, was sole respondent, prays for an adjournment, which is allowed. List this matter on
26.
26th of
25th or 26th?
26th is the last day.
25th.
24th of June.
Lordship.
You bring the instructions. On the ground that he has to bring certain instructions in the matter. Miss, your name, please? Our Miss Armid, he is present for the petitioner.
Obliged. May I please, Lordship? I beg to mention item number 12, my lord. In this case, my lord, item 12, my lord. And for
12.
petitioner, my lord, which has, my lord, survey copy of affidavit, my lord, that you file today, my lord. So let them may come in the next week, my lord.
You have to serve copy upon the respondent.
No, my
What?
lord, they have survey copy on me, my lord. They have filed affidavit.
Affidavit in opposition, you are for the petitioner.
I'll put up. Let them may fix on
Yes.
in the next week.
Mr.
Care board one.
K. Borwa, learned counsel for the petitioner, submits that the copy of the affidavit in opposition has been served upon him only today.
Them.
Today, and as such has prayed for some time to go through the same. Prayer is allowed. List this matter on.
Next week, any date, my lord.
List this matter on 16th of March.
Along with the affidavit. They have filed.
Yes, affidavit will be brought on record.
Obliged.
Your Lordship, with the consent of the petitioner, I beg to mention item number 8. Lordship,
8.
In this matter, I am appearing for 2 and 3.
7 and 8 goes together.
Yes, Lordship, I am appearing in 8. Lordship, I am on behalf of respondent number 2 and 3.
Mm.
During the pendency of this writ petition, there is some development in item number 8. So
Mm.
I need 2 weeks time for proper instruction from the department, Lordship.
Who is appearing for the petition?
For the petition.
In item number 8. Okay. Miss R.R. Kakoti, learned counsel for respond number 2 and 3, submits that she requires some time to get the full instructions in the matter. Prayer is allowed. It is not objected to by Mr. U.S. Bora, learned counsel for the petitioner. List this matter on.
I mean, item number 7. If both matters come together, Lordship, then it will be fixed on 11/6.
11/6. Thursday, next Thursday.
I'm
Okay.
item
List list the matter on 11/6. In item number 7 also you write list this matter on 11th of June. Yes. You have something to say?
In item number 7, I'm for the responding 1 and 2, my
1 and 2. Okay. Record his presence. Mr.
He was for my lord, on behalf of Endeka. He was for.
Okay.
Vinod Basfar on behalf of
Basfar on behalf of Mr. Andeka. For respond number 1 and 2 are present. Is present.
My Lordship, I beg to mention item number 48, my Lordship.
48.
It may be upgraded, my Lordship.
48 of the supplementary list. Yes. Upgraded means at 2 there is already a matter fixed.
Okay, at
So-
2, my Lordship.
At 2 days already a hearing matter fixed, so that will take some time. So after that, okay.
Deeply. May it please your Lordship,
Mm.
I beg to mention item number 16, Lordship.
16.
16 on 6.
Acha. What happened?
Pasha was for the day, Lordship.
I've taken the consent of the. I am for the applicant of I am. Kindly date may be fixed, my lord, after 1 week.
Okay. Mr.
Yes, Hussein.
S. Hussain, learned counsel for the petitioner submits. Prays for an adjournment, which is not
He's
objected
in
to.
respondent in IA.
He is the respondent.
Yes, read petitioner, yes.
Read petition, he is the petitioner.
Yes.
Petitioner and which is not objected to by Mr. A.K. Azad, learned counsel appearing for respond number 6. Prayer is allowed. List this matter when?
After 1 week.
List this matter on 17th of June.
Madam.
Yes, Mr. Rapsi.
Yes,
I make a
Mr.
mention item
Yes.
number 25, madam.
25.
Some instruction is required from the petitioner, so I could not meet him.
This is 2016 matter. I'll
My
not
lord,
adjourn it.
only 10 days or some days.
No, not even 1 day. 2016 matter. Imagine how many years have gone by. 10 years.
Updation information could not be.
You are
received
for the
from-
petitioner.
Yes, my lord.
What instruction you want at this?
Whether he has been given appointment or any other else, I do not know. So,
Okay, last opportunity, 1 week
my lord,
time.
for
Mr.
MS Ali, madam.
M.S. Ali, learned counsel for the petitioner submits that he requires to get certain instructions in the matter and has prayed for some time. Prayer is allowed. It is also seen that the matter relates to the year of 2016 and 10 years have elapsed. As such, only 1 week's time is given to the learned counsel to get the instructions. Accordingly, if we list this matter on 16th of June,
My lord.
you get the instruction, no more further
No, madam.
adjournments.
I have that.
Item number 47, I pray for some accommodation. This matter may be taken in the second half, madam, after the matter 2, madam.
Acha, 47.
47, madam. First half got some difficulty.
There is also a prayer for 48. So what happens is I'm in the midst of a hearing matter. Yesterday, because of time constraints, we could not finish.
Madam.
So today they will start at 2. So if time permits, I'll take it up.
Otherwise, madam, the first time, madam, I'll seek an accommodation if the matter reaches early.
Okay, then I'll
That-
keep
that-
it in for the second half.
Yes. If I can do it, I'll do it.
Yes.
Wait, please. Yes.
Yes. yes.
Well, on item numbers 31 to 36, Lord, they were in fact heard substantially by court number 23. In fact, 2 from the series were disposed of by that.
Oh, acha. So it is 31 to 36.
36 and 41 of supply is also related to this.
Acha. So, okay, let it be listed before appropriate bench,
Oh, yes.
right? And what else? You see, you said the
Supplementary 41,
41.
1. That is connected.
Okay,
Goes to court 23.
okay. Mr. B.D. Decker, learned counsel for the petitioner submits that the present case has been heard substantially by a coordinate bench of this court and prays that the same may be listed before the said bench. Accordingly, registry is directed to list the matter before appropriate bench, within bracket, Justice
R. Mojum.
R. Mujumdar. Yes.
May I please, your lordship? Lordship, I beg to mention item number 3. Lordship, the matter will be adjourned for a week. In the meantime, we'll file our reply.
Okay.
Next week.
Your
any
miss, your miss?
A.H. Attia.
A.H. Attia, learned counsel for the petitioner submits that she requires some time to file her affidavit in reply in opposition to the counter filed by the respondent. Prayer is allowed. List this matter.
Next week, any day, 10th
L-
to 11th, your lordship.
Okay, list this matter on 12th of June.
Much obliged, your lordship.
May it please your lordship. My lord, may I pray for listing of 2 interlocutory
You can
applications
approach the court master, he'll do
for
that.
correction of orders? Obliged.
Please, Lordship, I beg to mention item number 1, Lordship.
One?
That will be, yes, Lordship. That is part heard, Lordship. As per Honorable Court Order 31/10/2020, 31/3/2026, Lordship.
It is not
whether
mentioned
this
as part
appropriate-
heard.
Yes, Lordship. That is part heard, Lordship.
It is reflected in the order sheet. It is
Yes,
part
Lordship.
heard.
Yes.
Just show me
31,
item.
31/3/2026.
Acha. 31/3
3.
March.
Yes. The
I
fifth,
think within 1 month's time, if it is not heard, then the part heard thing goes.
is the matter in appropriate bench, Lordship.
That was not stated to this court when the last order was passed.
Lordship, wrongly listed. That's why.
When did you say it was made part heard? Heard in part.
But in
But
part-
I don't think so. It will remain part heard after the expiry of 1 month.
My senior is that.
Okay, let the registry verify. Mr.
Yan Borwal.
N. Borua, Learned Counsel for the petitioner submits that the matter has been partly heard by a coordinate bench. The registry is directed to verify the same and place it before the appropriate bench. Okay.
Your Lordship. Sorry, Lordship, item number 16, Lordship. Interim is there. Interim may be continued.
Or 60 not Harry Koidia. Interim order passed earlier shall continue until the next general day. Yes.
Lordship, with the consent of the other side, I beg to mention item number 30 of the daily lesson.
30.
Yes, Your Lordship.
Yes.
Your Lordship, in this matter, the respondents have filed their affidavit. We'll be filing our rejoinder during the course of the day. So if it is not convenient, can it be taken up after summer vacation?
Okay. Miss
As sure, my Lordship.
Ash Sharma, Learned Counsel for the petitioner submits that she requires some time to file the affidavit in reply to the affidavit in opposition filed by the respondent and has prayed for some time. Prayer is allowed. List this matter on 17th of July.
Your Lordship, we'll be filing our affidavit during the course of the day, Your Lordship.
Okay, reply within the course of the day.
Please, everything is item number 44, my lord. Here
40?
in this matter, my lord, our name has been wrongly shown, my lord.
44?
44, my lord.
Wrongly shown?
Yes, my lord. We have not signed in the Okalatnama also. I have
So
checked the
who
record.
appears actually?
Yes, ma'am.
You don't know?
Other advocate, some A.Z. Chaudhary or something like that, my lord. I have checked the.
Some
record.
Anjad Chaudhary is there, but this is not the one, right?
Yes, ma'am.
Okay,
And
we'll see
Mahajan and
the-
Devora maybe strike out, my lord.
Mhm.
And Mahajan and Devora is wrongly shown, my lord.
Acha. Mr. Bora, Learned Counsel, D. Bora, Learned Counsel submits that their names, his and Mr. N. Mahajan's name is wrongly shown as the counsels for the petitioners in the instant case, and as such has prayed for striking of their names from the array of the counsels. Prayer is allowed. Registry may strike off the name of Mr. D. Bora and N. Mahajan as counsels appearing for the petitioner in the matter. Yes, Mr. Roy? Last time, Mr. H. Gupta had some personal. Oh, yes, you're there. Okay. You have seen you have gone through the matter?
Yes.
Affidavits are there?
Yes.
It can be taken up for disposal? Yes. Yes, Mr. Roy?
My lord, the petitioner has approached this court for some area pensionary benefit, my lord, which was not paid to the petitioner.
Acha.
In fact, it happened like that. The petitioner, my lord, in the year 1994, took retirement and joined the Assam University.
He took voluntary retirement.
Well, a type of resignation, and in fact, to join a public sector undertaking. And there is a provision, it's called deemed resignation with pensionary benefits.
Acha. What resignation? Deep.
He was working in the BSF, Border Security.
Uh-huh.
Then in 1994, it was in 28/9/1994, he went and joined the Assam University at Silchar. 28/10/1994. Then thereafter, my lord, he made an application for granting him the pensionary benefit
By the BSF authority.
by the BSF authority. That is entitled under the rule. Now, when the BSF authority did not do this, my lord, for quite some time, he approached this court, also submitted memorials before the government of India. Then in 1998, on 9/6/1998, he was given the pensionary benefit. His pension was fixed at rupees 735. 735 at the rate, because in the meantime, the pay revision took place from 1/1/1996. He was entitled to some higher pension that was not given. The pension was fixed at 730 at the pre-revised rate.
But then he retired before the revision.
That's why he retired before revision. It's okay. I have no grievance on that. Now, my lord, he should have been given the pension from 1994. That was not given. He was given from 1998 on.
Oh.
If it is pre-revised, okay, but then it should be effective from 1994. That was not given. So in 1998, his pension was fixed at the pre-revised rate, 735. Then,
But his arrears were not given
Not
from
given.
94?
then, nothing was given.
From 96, regular pension was
Regular
given,
Pension was at this rate. But
pre-revised.
he opted for, commutation.
Mm.
Therefore, commutation value was granted. It was much later.
Mm.
Then commutation, he was given a total amount of some 1,24,000 and all.
Mm.
Fixing the rate at the 735.
Mm.
Then after 15 years, because he retired in 1994, 15 years, well, is 2009.
Mm.
He made an application that my pension should be restored because commutation was given from 15 years. I will not pay because 100% pension has been given. Under the rules, the pension restores the lot after 15 years. If one receives the commutation value of pension at a time 15 years, that is the rule.
Mm.
Then they say,
No, but just let me know about the commutation part.
my lord, if an employee retires, he can make an application commuting his pension, 1/3 part of the pension,
Mm.
and he will get a lesser rate of pension
Mm.
till he attains till 15 years.
After 15 years, that
Yeah,
amount
will
will
be
be.
restored.
Mm.
That was the rule.
Mm.
Now, since
So he applied for commutation.
he applied for commutation, he wanted a pro rata commutation, but then he was given, according to them, he was given 100% commutation. Means for 15 years they have given pension. 15
So
years
15 years, he did not get regular pension.
regular pension.
He got it after 15 years,
After 15.
2009.
2009 also they did not give. They say since your commutation was given in 1998, not in 1994, so your 15 years will come in 2013.
Acha, acha.
Therefore, please come on 2013, then we'll give you.
Mm.
He again approached in 2013.
Mm.
But in 2013, what they did, my lord, they revised my pension under the pay revision rule also from 1996.
Mm.
If my commutation is given, then it should have been given at the revised rate from 1990. They're saying that we are giving 1998.
Mm.
So if it is commutation 1998, that they should give it in the revised rate,
Mm.
which is 2,241 and so on. Not
But whatever it is, you retired earlier, no?
retired earlier because my pension is not given from
Not
1994.
given, 94.
94, that
Mm.
pension is not given.
98 it was given.
98 it was
By
given.
that time, revision had come into effect.
By that time, 1998, my pension was revised,
Mm.
but it was in the pre-revised rate.
Mm.
I wanted that the revision pensionary benefit should be given in the revised rate. That was given, but the commutation value was given in the pre-revised rate, not in the revised rate.
So it was not given.
It was not given. Therefore, I wanted either you give me pension from 1994 because I retired in 1994.
But you are entitled to those 4 years pension.
That is not given. And if I'm entitled from 4 years pension, if it is 1994, then 2009 my pension restores.
Mm.
Even in the old rate, if it will give. That is not done. So, my lord, in fact, my lord, my client retired long back. Yesterday I called him up. He said, there's some development. He said he is quite unwell. He said, I'll come up with some instructions to you. Because there may be some development. So he called me yesterday night. Said he's quite unwell. He will come very soon. So my lord, there may be some development. Therefore, your lordship may take it up some other day, my lord. Because
Okay.
he says that
Let us also know what is the development, or
Yes,
Mr. Gupta will know.
Also, I'll also find it out. Otherwise, my lord, the arrears part which has been said, my lord, in paragraph 20,
Hmm.
we have mentioned that the arrears from 94 to 98
Hmm.
amounting to rupees 94,000 was paid.
There is no disputer.
Oh,
I'm not
that is paid
disputing. There is
in the old revised rate.
Oh,
So far as commutation is concerned, Lord, once the pension is commuted, after 15 years, full pension will be restored.
Hmm.
So
So commutation was done in 98.
90,
that's right.
94, my lord.
No, 1998.
Because we have paid arrear pension also. Once the commutation, after the retirement, my lord, once he have opted for commutation of pension, although the amount was paid in the year 98, since there was a delay on the part of the department, those 4 years arrears was also paid to him. So
But it was commuted, what was he paid in 98?
commuted at the
No, no,
core
no.
rate, my lord. At the commuted rate, whatever pension he was entitled to, that arrear was paid from
No,
94 to 98.
it was only a pension, not commutation. That's why, Lord, let it be, Lord, your lordship will take up, maybe some developments, that's why, Lord. And he said, Lord, he's quite unwell after an old man, Lord. So can it be, Lord, after this? Because he may be, after the vacation, Lord, it's better, Lord, because the old man, but I do not know, he may be.
Mhm. Okay. As prayed for by heard Mr. P.K. Roy, learned counsel appearing for the petitioner, and Mr. H. Gupta, learned CGC or what?
CGC, my lord.
Learned CGC for all the respondents.
All the response.
For all the respondents. Mr. Gupta, Mr. Roy submits that he is yet to receive certain instructions from his client and has prayed for some time. Prayer is allowed. List this matter on 16th of July, Thursday.
Thursday, it's better. Lord.
Yes, Mr. Sinha.
In this case, affidavit is necessary, Lord.
Mm-hmm. What is necessary?
Affidavit is necessary, Lord.
So they have not filed. Yes, Mr. Talukdar.
My lord, some direction to finance department, my lord. And accordingly, kindly peruse the last order, my lord.
No, what is the order date? Furnish the instruction, finance department, R. Borpujari.
My lord, the petitioner was not present on that day, so lordship,
Huh.
subsequently, due to curiosity of time, my lord.
Okay, we call Mr. R. Borpujari. He has some instructions, it is said. Okay, you inform him and bring him after some time. Yes.
Previous occasion, the respondent.
Acha, Miss Bhattacharya, you wanted.
Yes, Lordship, actually the concerned officer, he is out of station, Lordship. He is on, I think, some duty in Durham, Lordship. So they could not give me the updated status. They asked for some more time, Lordship.
Okay. Miss M. Bhattacharya, okay. Miss M. Bhattacharya, learned additional senior government advocate, submits that the concerned officer who was supposed to give her the instructions is engaged in some other district, and as such instructions could not be furnished. She therefore prays for some time to get the instructions. Prayer is allowed. List this matter when? You suggest a date?
2 weeks, Lordship. after-
List this matter on 19th of June. 19th of June is okay?
Deep yoga.
Item 6.
Yes, Ms. Chaudhary? The pleadings are complete?
Yes.
Yes, Mr. Talukdar, you are there.
My lord. My lord, affidavit, my lord.
Affidavits are filed.
My lord.
Alexa, page 40.
Page
Page 40.
40. Yes.
Here, this order has been passed without giving any opportunity to the petitioner of hearing, and no evidences were also taken, no witnesses examined, my lord.
So what happened? He is,
Only on the basis of a report submitted by the DE, the District Elementary Education Officer, action has been taken against the petitioner. Your lordship may kindly see the last para. I'm reading it. In view of the above facts, in pursuance of the inquiry report submitted by Julio Hailakandi, it has been found that the allegations against the delinquent teachers are true. So on the basis of the, my lord, inquiry report submitted by the district elementary education officer, they have, it is stated that the allegations have been proved. Without, my lord, following
So
the procedure
departmental
as
proceeding
per
against you
Rule
will
9
be
of the
concluded.
Assam discipline and.
But a further statement, disciplinary departmental proceeding
Nothing, my lord.
will be concluded after recovering all the financial liabilities incurred on the petitioner due to misappropriation of fund.
So, my lord, only after issuance of notice in this writ petition, the respondents have issued notice to the petitioner to appear for hearing. So in three numbers of notices were issued. I have filed my.
What is the
insurance-
penalty? What is the punishment given?
Punishment is for recovery of amount from his salary, my lord.
Hmm.
So I have filed additional affidavit, page 47, para 3.
Now the inquiry proceeding is, now the departmental proceeding is over.
Now they have started, only after, my lord, receiving notice in this writ petition, my lord. Your lordship may kindly see the dates of the notice. Here we filed the writ petition was first listed on 4/11/24, and notice was issued on 11/11/24. The respondents have issued notice to the petitioner to appear for hearing on 11/11/24. Page 47, I am reading para 3. That during the pendency of the writ petition and after receiving notice of this honorable court in the aforesaid writ petition, the respondent authority suddenly started the departmental proceeding by serving show cause notice dated 11/11/24 to the deponent. Upon receipt of the show cause notice, the deponent submitted his reply dated 14/11/2024, which was duly received by the office of the director of elementary education. It is worth
So
mentioning.
these are all during the pendency of this writ
Yes,
petition.
my lord. Subsequently, two numbers of notices were again issued. One is dated 18/3/2025, another 2/9/2025.
So these are show cause notices.
Yes, my lord, only after, my lord, during the pendency of this writ petition.
So now what are your prayers?
That since the order was passed without following the procedure of law, so this order, my impugn order may be set aside. And if they hold any inquiry, the petitioner will participate. That is a different issue.
Oh, they have started holding
Yes,
the
ma'am.
the proceeding and petitioner was called for. Now he can participate.
Yes.
Only that order has to go. Because this is only an inquiry report, order based on inquiry report. Preliminary inquiry, that too. Yes, Mr. Talukdar, what do you say?
Already, my lord, 3 times, my lord, notice was served to the petitioner, my lord, but we have stated in our affidavit that he has not appeared, my lord. So,
This is all during the pendency. Right, Mr. Talukdar.
my lord.
All during the pendency of this writ petition.
So at this stage, my lord, my humble prayer that, my lord, later, my lord, taken up on some other day. In the meantime, my lord, I will collect the present status, what is going on.
There is no present status. She will,
That status.
no, he will participate in the inquiry, in the departmental
He-
proceeding.
He may be participate in the meantime, my lord, so.
No, he
No,
is,
my lord, no. Only, my lord, my lord, last notice was issued on 2/9/2025. And the copy of the notice was not served to the petitioner. It was received by the headmaster of the school. And the headmaster furnished to him only one day prior to the date of hearing. The hearing was supposed to be taken at Gauhati and the petitioner lives in Hailakandi. So it was not possible for him to come. So that is why he.
so he did not appear in the hearing.
ma'am.
Some subsequent date is given.
He did not appear. Because he did not receive the notice in time, my.
Okay, then let the matter be kept pending till your conclusion of the departmental proceeding.
My
He will participate, but regarding this.
He will
my lord,
participate, he couldn't go on that day. Some
only one
subsequent,
date, yes, my lord, another notice may be issued, he will participate, he will come. I have, my lord, explained my lord, why he could not come on the, only one date he did not come. The first day he submitted his reply, he furnished him just one day prior to the date of hearing. after the same was received by the headmaster, he had no authority to receive the notice on behalf of the petitioner. Petitioner did not know whether regarding any notice. Petitioner did not give him any.
And in subsequent dates, he went and appeared.
Sir,
No,
there-
my lord,
Subsequently, there was no date.
Kindly peruse the affidavit, my lord, 58, my lord, page. My lord, we have categorically stated that for finalization departmental proceeding, officers scheduled hearing notice on 18/3/2025 and
58.
58, our affidavit, my lord. Paragraph 3, my lord.
These are the
Hmm.
notices which I have annexed in my additional.
16/5/2025, as the delinquent teacher was found absent in first hearing without any intimation. However, the second hearing also petitioner did not respond. Final opportunity was given by the office of the petitioner 8/9/25 for hearing. Notice was issued accordingly.
Yes, my lord, two notices. One is 18th, another is.
So what happened to this final notice?
For hearing notice issued.
Did he go and appear?
You had reported that hearing notice was served to the petitioner by BEO Hailakandi through CRCC and headmaster of the school, but he refused to receive the hearing notice, madam.
So now the petitioner will participate.
But then your participation is not forthcoming from here. You have not participated. Okay, one day you received the notice late. But what about the other days?
Days, my lord.
No, final opportunity was given by this office on so-and-so for hearing. Notice was issued. Has reported that a hearing notice was served.
But not served to the petitioner directly, my lord.
Okay, but then you came to know.
Only later on, my lord.
That was
But
one
here
date.
we-
What about the other dates?
Second day also same thing happened. It was received by the headmaster, my lord. The second one, the headmaster, my lord, informed him through WhatsApp, my lord.
And on the day before the hearing?
Yes, my lord.
But we have stated that
Here, my lord.
headmaster given him, but he refused to receiving the hearing notice, madam.
It's not correct.
So that's why, my lord.
It cannot be twice that headmaster had given you one day before the hearing.
No.
It can be okay for once, but then it
So-
thinks
Ready to appear, my lord.
So lordship may,
If it does
Ready to
they can
appear?
take action against the petitioner.
ready to appear, but he is not appearing.
Let them issue notice, he will appear. If he does not appear, they let them take action.
so let the matter keep pending. In the meantime, we will again serve notice, my lord, whether he appear or not, my lord.
But,
Mm.
my lord,
So-
your lordship may kindly see this order. This order was issued, my lord, prior to issuance of these notices. This order itself is, my lord, liable to be, my lord, dismissed, my lord.
He is a teacher of a provincial high school.
Yes, my lord. Without following due procedure, they.
But Mr. Talukdar, that notice, that impugn order is bad, it seems. Because before issuing any show cause, before the disciplinary proceeding,
That's why,
nothing.
my lord, I pray for some accommodation so that I can place before your lordship that
And in
up to date status, my lord, whether Sokos was not, notice was issued or not.
No, show cause notice was issued during pendency of this writ petition.
See the dates. Dates are there, my lord.
But
Dates
then
of
the fact
notice.
remains that he is not participating in the process.
My lord,
My lord, now the writ petition is pending, my lord. Petitioner also does not know the outcome of the petitioner, this writ petition, my lord. He was also waiting for the outcome of this writ petition. What will be the result of this writ petition, my lord?
One thing can be done, Mr. Talukdar, I'll set aside this order and then let him participate in the departmental proceeding, and if he does not participate, ex parte it will follow.
my lord, that's why, my lord, I pray some accommodation. In the meantime, we will again.
No,
send
that is a
notice, my lord.
separate issue, that departmental proceeding.
Lordship,
Keeping this matter pending, my lord. So this order is liable to be set aside, my lord. All these notices were issued after this order. They should have issued prior to issuance of this impugned order.
Acha, where are those show cause notices you have
Annexed
in the
additional
reply?
affidavit.
Yes, in the additional affidavit.
Yes, my lord. And the same notices they have annexed in their, my lord, affidavit in opposition.
11/11/24.
Yes.
When was this writ petition filed?
The writ petition was filed on 24/10/2024, and it was listed first on 4/11/2024.
Okay, heard Miss S.B. Chaudhary, learned counsel for the petitioner, and Mr. B. Talukdar, learned standing counsel for
elementary.
elementary education. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside of the order dated 19/8/2024 issued by the Director of Elementary Education, Assam. Where is this order? 19/8?
Annexure J, page 40.
Oh, yeah, this is the one. Mhm. By which the financial liabilities by which it was concluded that the petitioner is found involved in a in a case of misappropriation of fund, and all the financial liabilities were directed to be recovered from the petitioner. Full stop. The petitioner has also challenged the inquiry report dated 6/5/2024 issued by the District Elementary Education Officer, Hailakandi. Where is that?
That I have not annexed.
You are praying for setting aside without annexing.
I am, my lord, praying for set aside only this order.
But then the prayer involves that also, the inquiry report. Nalagi last line to full stop. The case of the petitioner is that he was working as the senior-most assistant teacher in Hinglaipar, HINGLAIR Lower Primary School, Hailakandi. And while he was serving in the said capacity, in the said school, he was also looking after the midday meal provided to the students of the said school. Full stop. As per the practice and procedure, he being the head teacher should pay for the midday meal meant for the students from his own source, which is being paid later by the department department on bills being raised. The petitioner states that an amount of rupees 40,147 for the period from December 2021 to June 2022 was to be received by him from the midday meal account of the school, which he had spent. He also states that he was supposed to receive another amount of rupees 9,080.24 from the SMC's account. What is SMC? School Managing Committee. From the School Managing Committee's account for purchasing materials by the petitioner in connection with some festival. However, he submits that on charges of gross financial misappropriation and misuse of government money, as well as for insubordination to higher authority, the petitioner was placed under suspension by the order dated 2/7/2022. So that suspension order he has challenged and High Court has given.
Set aside by this honorable court, and he was reinstated. Kindly turn to page 37.
The
He was
petition,
reinstated in
37.
37.
The petitioner had put to challenge the said suspension order by filing a writ petition before this court, which was registered as WPC number 7922 of 2022. And this court, by order dated 6/1/2023, had set aside the said suspension order and in pursuance to the same, the petitioner was reinstated to his original post by order dated 4/4/2023. However, a departmental proceeding was directed to be drawn against the petitioner by the officer, the Director of Elementary Education, Assam. In compliance with the said order, the DEEO had conducted an inquiry. But you see here, Mr. Talukdar, in the impugned order,
My lord.
the office had asked the DEEO to draw departmental proceeding by appointing inquiry and presenting officer and submit the findings of so-and-so to DEE, director. But he himself had inquired. Right.
Yes, my lord.
Okay. কি করলো? Oh. In pursuance, dear, compliance null. In pursuance to the said order, the DEEO had conducted an inquiry and submitted a report to the Director of Elementary Education on 6/5/2024. Full stop. In the said report, it was stated that the petitioner has withdrawn 70,000 rupees, 70,000 for utilization of multi-sectoral development program fund, multi-sectoral development program fund from the school management committee. But he did not submit any progress report for the said utilization. Full stop. It was also stated in the report that the petitioner has withdrawn 23,000 rupees for rupees 23,000 for midday meal and misappropriated the fund. It is also reported that the petitioner went against the direction of the DEEO, Hailakandi, by not handing over the charges of the head teacher to the next senior most assistant teacher. Further, the petitioner was also found involved in misappropriating money. in view of the said facts, and in pursuance to the inquiry report submitted by the DEEO, the Director of Director of Elementary Education, Assam, held that the allegations against the petitioner are proved. It was further proved in the impugned order dated 19th of August 2024. The Director of Elementary Education stated that the departmental proceeding against the petitioner will be concluded after recovering all the financial liabilities incurred on the petitioner due to misappropriation of fund. Where is this High Court's order of 31/5/24?
That is the statement order.
Acha. Full stop, para. It is this order of the Director Elementary Education, Assam, which is put to challenge by the petitioner in the instant writ petition. The learned counsel for the petitioner submits that during the pendency of the present writ petition, the petitioner, the authorities, wait, where is your reply? Yes, the respondent authorities started the disciplinary proceedings by serving show cause notice dated 11/11/2024 to the petitioner, to which the petitioner had submitted his reply on 14/11/2024. The counsel further states that subsequently 2 numbers of notices were again issued to the petitioner on 18/3/2025 and 2/9/2025 for the purpose of hearing. Full stop. The petitioner was asked to appear for hearing at Gauhati. But since the notices were served upon him lately, he could not appear in the hearing. Further, it is stated that on behalf of the petitioner, the principal of the said school had received the notice and he was intimated about the same very late. The learned counsel for the petitioner submits that the petitioner would appear or would participate in the departmental proceeding as and when he will be called for. Full stop. Para. It is seen that the penalty of recovering the money from the petitioner was decided upon on the inquiry report submitted by the DEEO, Hailakandi. Whereas in the order dated 19th of August 2024, the Director of Elementary Education had asked the DEEO Hailakandi to draw up the departmental proceeding against the petitioner by appointing the inquiry officer and the presenting officer and submit findings of the departmental proceeding to the Director of Elementary Education. However, it is seen that the DEO had submitted a report to the Director of Elementary Education, and on the basis of that report, the said penalty was already imposed upon the petitioner. The Director of Elementary Education had stipulated in the said order that the allegation against the petitioner was proved in pursuance to the inquiry report submitted by the DEEO. It was further stipulated that the departmental proceeding against the petitioner will be concluded after the money is recovered from the petitioner, which is not according to the law. He will be under discipline and appeal rules, right? 1964 law as provided in the Assam Civil Services, what? Discipline and appeal rules, 1964. 1964. Wherein Rule 9 provides for the entire procedure as to how to conduct the departmental proceeding against a delinquent employee. In the instant case, in fact, it has been seen that the departmental proceeding had commenced and show cause notices were issued to the petitioner after the instant writ petition was filed. It is also seen that the petitioner has filed his reply and the hearing is on. In view of the same, it is therefore directed that the petitioner should appear before the appear during the departmental proceeding without failure, without any fail. And the authorities concerned will have to take the departmental proceeding to its final outcome as per the law provided in the 1964 rules. The respondent authorities would then impose the punishment as required, if any, upon the petitioner on conclusion of the departmental proceeding. In view of the same, the order dated 19th of August 2024, passed by the Director of Elementary Education, Assam, is hereby set aside and quashed. Writ petition is disposed of, right? That will do? Yes. Mr. Talukdar?
My lord.
So he will appear and whatever punishment you impose, but not in this manner, as per Rule 9 of the 64 rules.
My lord.
Yes, petition is disposed of. Forget. Yes, Mr. Ahmed and Mr. Ahmed, you have some matter here. Hearing. It is down the list over. Hearing. Item 29. Okay, you can come after some time. Let me finish up the admission matters, then I'll take up your hearing first. Okay, Miss Datta. Yes? Let him be here. Yes.
Mr. Solia is there from.
Ha.
instruction, Lordship will just go through the,
Huh.
Lordship, here the issue is petitioners are trained graduate teachers
Hmm.
and they've been placed under a fitment table on the basis of which their revised pay scale and revision is done. Now, petitioners filed this writ petition saying that similarly situated teachers have been placed in a different fitment table.
Fitment table,
Yes,
yes.
on the basis of the fitment table, my Lordship, here, the petitioners are in the fitment table 1.9.
Mm.
Lordship, in the gist of it. Petitioner claims that similarly situated teachers are there who are getting the benefits of fitment table 1.8. That is the gist of it. So the teachers who have been getting the pay structure on the basis of fitment table 1.8, subsequently they are getting a higher rate.
Acha.
That is the main issue. So here, Honorable Court had directed, we were not a party, but we were directed to get the information whether and why that disparity is there and why. So, Lordship, here the
But
clarification.
he is in the fitment table for 1.9.
Yes.
I'm 1.9. I'm getting less salary than my.
Now,
other colleagues.
Lordship, here as per ROP and or as per our rule, they are getting the right scale of pay
Mm.
as per. But the similarly situated teachers, Lordship, who have been placed in the fitment table 1.8, there regarding that we have sought a clarification from the education department. That is what we are written in the instructions. Although since we were not
And
a
they
party.
are entitled for a higher rate.
No, Lordship, that there is, as per our communication, they are getting the right scale of pay.
Acha.
But the similarly situated teachers, Lordship, since we don't have the record, education has the record of those two. We have called for those records that what is the case, because as per our instructions, they should be getting a lower pay scale. The similarly situated.
But then they are getting higher.
They have the grade pay is similar to them, but since they have been placed in the fitment table, different fitment table, they are drawing a higher scale of.
Acha.
So that clarification has Lordship. It's written in point 2 of our that Lordship will see underneath the table.
Hmm.
There's a table, Lordship. Underneath the table, it's clearly said from the table. It may be seen that trained graduate teachers with
Under the table, it is, it needs to be clarified.
Oh, Lordship, sorry, my instruction is.
Acha, I'll read the entire one. Wait.
Yes, there's a clarification that has that the department has sought.
This is by the finance department.
Yes, we have written to the Commissioner and Secretary, Education
Yes.
Department.
Today I am informed that a copy of the petition has been received from the Nadu Filing Council. So, okay, I mean, this similarly situated people who they had drawn pre-revised grade pay
Lordship.
and they were allowed the grade
They were
pay.
getting a lower rate initially, Lordship.
They were
When they-
getting a lower by 200. But then they were allowed to draw a grade pay of 7,400.
Yes,
It comes at
that-
par.
Yes, they.
Right.
So they are trained graduate teacher, that's why.
All are trained graduate
Yes, Lord.
teachers.
No,
No, but here, Lordship, those trained, but we have to see at the entry level, what was the qualification? Was being a graduate necessary? So as per the fitment table.
But okay, untrained graduate teachers pay is okay.
But they were just, and these, the similarly situated petitioners, lordship, well, not the petitioners, similarly situated teachers, they were drawing they were getting the pay scale of 2,500.
At par with untrained.
Yes,
So they were untrained or what?
yes, lordship, maybe at that time,
Maybe
yes,
at the entrance.
gradually they got the qualification, they became graduate, but that does not make them entitled to that pay scale. So now this clarification we have asked from the education department, because we form the fitment table. How, on whom they're giving what fitment table, that is done by the administrative department. So
Fitment table is otherwise yours.
we create the annual increments and all, how it is, we make those fitment tables. But on whom they are applying, that is done by the administrative.
It actually place them at fitment table number 1.9.
Yes.
That is not.
Why it is 1.8 and why is it 1.9? Why they are getting 1.9 and why others are getting 1.8? That clarification has to come by the administrative department.
That's
Because-
why lordship,
Instructions are
detailed
required.
affidavit is necessary, either from the.
No,
finance
from
or-
our
But
department.
they are
we are-
not made a party. It's only that instructions.
Yes,
were-
especially that,
No, no, that clarification, lordship, the main
No.
clarification, if that is come, that is the just, because if he's claiming something that similarly situated teachers are getting, but if a distinction can be drawn, that distinction has to come up from the education department.
It doesn't matter whether you are in 1.9 or 8. You are getting the same pay.
no, I'm getting less. pay.
After that,
7,400, great
No,
pay.
no, that's the
after
great pay.
after the
Great
fitment
pay.
That's the great
application of
pay.
fitment table, there's a, I think,
Acha, there's-
disparity of rupees 720 or something.
So, sir, there is some provision adding.
Yes, if he was placed
Not
1.8, maybe.
Okay, so it needs to be clarified how similarly situated teachers are getting more, right? In view of the above, you are requested to furnish the above clarification within so and so. So the finance has asked for certain clarifications from the education department.
Yes,
So let the clarifications come. They need not file an affidavit because they are not
And
a
lordship,
permit.
Copy of the instruction may be given because
No, I'll
without
furnish
instruction,
you-
I cannot.
Yes,
reply.
yes, yes.
But that-
Okay. Heard Mr. A.K. Sinha,
SK Singh.
S.K. Sinha, learned counsel for the petitioner, and Mr. B. Talukdar, learned standing counsel for elementary education, and Ms. Borman, you are there? No. And Mr. A. Chaliha, learned counsel for the finance department, standing counsel. Although the finance department is not made a party in the instant writ proceedings, but clarifications were, or some instructions were sought for from the said department. And in pursuance to the same, and in compliance with the same, the learned standing counsel for finance department has placed an instructions which shows that the petitioners are trained graduate LP school teachers who were drawing the pre-revised grade pay to the tune of rupees 2,700, and they were allowed to draw the revised grade pay of rupees 7,400, and they were placed in fitment table 1.9. Whereas similarly situated trained graduate LP school teachers who were drawing pre-revised GP grade pay of rupees 2,500 were allowed to draw grade pay of rupees 7,400, and they were placed in fitment table 1.8. During the it was found out by the finance department that there is discrepancy in the amount ultimately drawn by the similarly situated graduate teachers, which is higher than the petitioner, who were placed at a different fitment table. Further, the instruction shows that a clarification is sought to be obtained as to how similarly situated trained graduate LP school teachers who were drawing pre-revised grade pay at a lower rate than the petitioners were allowed the grade pay of rupees, or were allowed the revised grade pay of rupees 7,400. As such, the finance department had requested the authorities in the Department of School Education to furnish them the said clarification. In view of the same, the counsel for the finance department prays for some time so that the clarifications are received from the Department of School Education.
Lordship, they can just counsel for the Lordship, finance department is not seeking time, Lordship, education is seeking time because they'll have to produce, if they can just produce the clarification on the next date, education.
Time question that he wants time. Na lage. What did I say lastly? No, no. As such, the Standing Counsel for the Finance Department has placed that clarifications would be received from the Department of School Education. As such, Mr. B. Talukdar, learned Standing Counsel for Elementary Education, has prayed for some time so that clarifications are given to the Finance Department and the resultant discrepancy will be established. Prayer is allowed. List this matter on 22nd of June.
Or my lord, immediately after vacation, my lord.
After
Let
vacation.
them file affidavit also, affidavit will come
After
next day,
vacation,
otherwise also-
I mean, elementary had not filed affidavit.
No, my lord.
It is further directed that the Department of Elementary Education may file an affidavit in the instant matter. List this matter on then 13th of July. 13th of July, after vacation.
Object.
It could be divided. Okay.
Lordship, in item 9, I am seeking for an accommodation, Lordship. I could not go through the record. We have received the record, Lord.
Okay, after.
May come up on Monday.
Monday, it will be difficult, Lordship.
Uh,
Tuesday, on Thursday or Friday, Lordship, next.
Okay, on 11th then, Thursday.
Okay.
Miss M. Bhattacharjee, learned additional senior government advocate, seek some time to go through the records. Prayer is allowed. List this matter on 11th of June. Yes, Mr. Bora.
My lord, here,
Your lordship,
my lord, before starting, my lord, my friend, my lord, there is another petition is, my lord, same issue, my lord, and same order was passed, my lord, is WBC 6012 to 2024, my lord.
It's okay. Let us
So-
hear
so,
these two.
This,
That will follow.
on the Thursday, Tuesday, 9, my lord.
No,
if I may
no,
come.
I have them difficulty.
No,
Because on last occasion also.
Yes,
full
my lord.
time, Your lordship, there was.
On
So
on
all the last
Tuesday,
orders, your
Tuesday, my lord, 9, my lord.
Lordship, I have a difficulty because, anyways, the matter is very hard to get a matter.
My lord,
The
all
matter
three-
was taken
My
up
lord,
on 18th last-
Lordship,
was fixed today. It took time.
on my lord, on the
order
consent of the
itself
both
reflects
parties,
the-
my lord, on consent, my lord, on last occasion.
He is
not
not
my-
giving consent. Where
Yes,
is he giving
given
consent?
given consent, my lord.
No, he has
Last
objected.
My lord, this, my lord,
We have a difficulty.
my lord,
that's
my
why-
learned friend, my lord, this on morning told me, Lord, you may take time, my lord.
Who?
It was
Your lordship?
on last occasion, my lord.
No, no.
No, it doesn't seem so.
Yes, last occasion.
Maybe you heard something else.
Yes, no, my that is there. Ma'am, page
Your lordship,
145, my lord. Page 145, my lord, this Amit Jadhav, my lord, this same,
No, no,
three
that-
representation is there, my lord.
That's why I have
My lord,
tagged that matter.
Lordship, page 143, my lord. 143, this is a representation filed by three. representation filed-
143.
Yes, my lord. Three representation filed, my lord. One is, my lord, the Krishna Kumar Sharma, the present here, my lord. The-
I am the petitioner, Your
Yes,
lordship. If I have to say if a matter is similar or not.
No, where
It
department,
is
my
for
lord,
the
is to
defense.
clear passing the order, my lord, only this on, next on, 9 Tuesday, my lord.
He wants a reason to get it deferred. That is why it is third petition.
Your Lordship, that
Not
is
required, but then, okay, he is praying for time. Can you concede or what?
Your Lordship, if I may just start, because the matter issue is very simple.
No, if you start, I'll end it. Then you have
Yes,
to,
Your
Now, what is the difficulty?
This-
Do not
Actually,
matter.
actually,
This matter
this
is
my
difficult, yeah.
instruction is, my lord, from the department, my lord. This common judgment was passed, my lord, in three representations. The issue is same, my lord.
No.
So, my lord, is, if my lord is, should be heard in the same, on another date, my lord, on nine,
No, Your Lordship,
on nine. Nine, my lord, is today is, my lord,
Okay, next Tuesday, Mr.
yes, my
Bora.
lord. Nothing like
No
that.
further adjournment. On
Yes,
next,
yes, yes.
no, other matter will not be taken. Let us hear these two.
Yes.
The,
Because the other matter is fixed on 23rd. That's a different issue altogether.
My
It's
lord,
fixed on
my lord,
23rd.
when,
I am
my
clear
lord,
of
when
the
this
other matter.
earlier order was passed, my lord, this, my learned pen, this submission was the common judgment, it was passed, my lord, page 143, my lord.
I never submitted any.
it's okay. He's saying that that's a different issue. I'll not tag. You do it on Tuesday then, okay? Okay.
Last opportunity.
Last
No, no,
opportunity.
yes, my lord.
Mr. S.K. Medi, learned CGSE,
CGC.
praise CGC. Earlier it was CGSC,
Yes,
now
my
it
lord,
has
Central
become
Government Standing
CGC.
Council it was, my lord. In Cat, my lord, now also it is CGSC, my lord. Here, my lord, Central Government Council. in High
He's
Court.
not standing, sitting. Mr. S.K. Medi, learned CGC, prays for a short accommodation so that he can prepare the case. Prayer is allowed. List this matter on 9th of June. However, the adjournment is granted as a last chance.
My lord,
On
I'll-
9th June,
my lord, I'll argue, my lord.
endeavor will be done to dispose of the
Yes,
case.
I'll work on that.
13 to give, oh, time learning. Yes.
Lordship, we have filed additional affidavit, Your Lordship, yesterday.
You have filed additional affidavit yesterday. You have given him the copy?
Yes, Lordship. We have
So-
just received today.
So, okay, sometime.
Lordship.
Miss,
Order.
our daughter, learned counsel for the petitioner submits that she has filed, that the petitioner has filed the additional affidavit yesterday. The learned counsel appearing for the respondent submits that he got the copy today. As such, prayer is, time is sought for, which is allowed. List this matter on.
Any day, Lordship.
You suggest
Uh,
before vacation.
Yes, Your.
List this matter on 17th of June.
Much obliged, Leadership.
Yes, Mr. Bora?
Lordship, here challenge is made to the disciplinary proceedings.
Hmm.
Your Lordship, if your Lordship.
What about the other party? You are there?
Mr. B. Chakraborty is there, CGC.
Who?
B. Chakraborty,
CGC,
CGC,
not SK Medhi.
not SK.
Okay, then call her. She is a lady.
No, Biplab Chakraborty.
Oh, B Chakraborty.
Chakraborty.
Yesterday he was there. Call him. I'll take it up after some time. Oh, she's there. You are there for other party.
NHA.
Oh, church. Okay.
Yes.
Yes, Mr. U Sharma.
Lordship, the matter may be
Oh,
adjourned.
PN Sharma. Yes, huh?
Lordship, the matter may be adjourned for the time being. Conducting council is at legs in another court, Lordship.
After some time.
Lordship.
Here also, we have to file our affidavit otherwise.
Hmm?
We have to file our affidavit.
Let Mr. BM Deka come.
Lordship,
Okay.
we'll file our affidavit otherwise.
I have filed in 2 cases for NIS.
You have filed your affidavits.
Cases I have filed.
Okay, let Mr. Deka come. He may have something to say. Yes, Mr. Purkasto?
And this case is, my lord, second round of litigation,
Hmm.
and
No affidavits by the respondents?
Yep, I just appear for the pension department. We have got no role in this matter to play, Your Lordship.
Acha, who otherwise will have?
Water resources, finance and AG. Your Lordship.
Okay. So Mr. Buddha Gogoi can come, you can inform them.
water resources.
My lord, I'm appearing from Water Resource Department.
Acha, so today you are ready? Or you will file your affidavits?
We have received our instructions, however, the instructions are insufficient, so we're seeking for some time.
affidavit for the
Inspections in this case,
We'll be filing our affidavit in this.
they have
filing.
taken time on several occasions.
They have taken time in March.
Yes.
Respondents may complete their instructions and file necessary affidavits.
Moreover, it is covered also. The Honorable Supreme Court in several occasions has already settled this issue, my lord. Ruben Dash has also gone by this time. So, my lord, the petitioner is retired and his pension is not been settled till today. So.
So what happened? Instructions are awaited. What instructions?
We have received for instructions. However, the same is not sufficient for us to file our affidavit, my lord. So we're seeking for 2 weeks time, my lord. By 2 weeks time, we'll do the needful, my lord.
What instructions they'll have to have?
They will have, only department cannot at this stage they give any instruction because unless and until this honorable court gives mandamus, my lord, they cannot, they will not proceed. Earlier occasions, this honorable court has directed for directing them to consider. They have not considered.
So instructions perhaps is not required. You can orally submit, right? You are for water resource.
My lord,
You are a standing counsel of the water resource.
I'm appearing on behalf of the standing counsel,
Oh, you are appearing on behalf of, who is the standing counsel?
RM Das, ma'am.
Where is RM Das?
RM Das, he's not present. However, he is another engaged counsel. And the engaged counsel due to some emergencies.
Okay, I'll give him 1 week's time. Call Mr. RM Das, okay?
My lord.
He is otherwise not the standing counsel also. Okay, as prayed for by learned counsel appearing on behalf of the standing counsel of the Water Resource Department, list this matter on 12th of June. Okay?
Much obliged.
I appear for respond numbers 7 and 9.
Mr. D. Bora for respondent number 7 and 9, and you?
Respond number 6.
And Miss?
Tenno on behalf of article.
Okay, I couldn't hear it. You write it in a sheet of paper. For respond number 6, are present. Last time, handloom and textile, Mr. Dhar, you took time. You are ready?
My lord, only the thing is that, yes, my lord, I have gone through the everything, my lord. We'll need to bring the record because there is a, my lord, order of the handloom and textile, bringing him one step down from UDA to LDA. And
Oh, UDA to?
Yes.
Okay.
And how the justification they have, my lord, it's not very clear in the order or in the affidavit.
Achha.
So, my lord, so the justification will be in the record. But one thing, my lord, he is talking about pension, my lord. Pension, my lord, we did not deny. That is what I saw. So he can apply for the pension, my lord. Because
But how will his pension be calculated? On a demoted post or what?
my lord, that will be calculated. That can be calculated, my lord. If suppose as of
But
today,
first of all, whether his demotion was okay or not, we'll have to see.
yes,
Then his pension will be calculated.
my lord,
So for that, you need to see the records.
records, my lord. My lord will then, because I wanted that he should at least apply for the pension, my lord. Because pension, my lord. So
Provisional pension you get.
he should, my lord. Because my lord will come to in our affidavit 106 page number.
What is the prayer in this petition? For allowing him pension or for demotion also?
Both.
Both.
At least, my lord, he is not getting provisional pension. That he should avail, my lord.
Provisional pension he is entitled to. He'll have to be paid.
Exactly, my lord. That is what 106, our affidavit, my lord.
Huh.
We asked him to come and submit his papers. So, my lord, at least in the meantime, he should.
So he doesn't want provisional pension.
No.
He wants his first to be decided.
After retirement, through one letter, I was directed to submit the papers, Lordship. Accordingly, I went to the office to submit. But since a judicial proceeding is also pending, they have not taken the papers, Lordship.
Oh, then?
In our affidavit, we said that, my lord, that.
But then he went and it was denied.
Maybe, my lord, because that is an administrative thing. I'm just submitting from the affidavit, my lord. What is there?
So why keep him hanging for long? Let us hear the matter.
My lord, but my lord, that part, my lord, why he was brought down, that
must be in your affidavit.
no, my lord, because it is there. We said because of a High Court's order, my lord. I have gone to the order, my lord. There is nothing specific. It is regarding fixation of other pays and all. How it was brought down, that justification will be there in the record. That is what, my lord, I'm just into. court, that justification will be in the record.
Mr. R. Dhar, learned counsel, learned standing counsel no, learned government advocate,
My lord,
standing counsel for handloom and textile department. Submits that the records would be necessary for the proper adjudication of the instant case. And as such, prays for some time to place the records. Prayer is as such allowed. What do you have to say? Records not necessary.
The ordinance, because they have said that through order of this honorable court, they have demoted the petitioner. I have annexed that order also, Lordship. In that order, it is nothing specifically stated that demotion has to be done.
But then he wants to see the records.
Lordship,
Why?
then, Lordship,
Hmm.
at present, subject to the disposal of the said petition, let him pay the provisional pension as LDA, Lordship. Because that has to be decided by this honorable court whether he is to be.
Okay, provisional pension you,
I'm not denying, my lord.
Sir,
That is what I'm telling.
but then you have to instruct your officers to not to deny him. He has gone, he was not accepted.
I can, my lord. I can always, I was not in knowledge of this, just here.
Okay, records of the case, huh? Prayer is allowed. However, it is also, it is stated by the learned counsel appearing for the petitioner that in pursuance to the letter asking him to appear with papers for his provisional pension,
No, that
the
not,
petitioner
that is not for provisional pension, Lordship. That is for pension.
Full pension, my lord.
for pension.
Yes, Lordship. At page number 66 of my writ petition.
No, I saw a letter asking you to appear with papers. Where is that?
Page-
You
page
have
num-
just shown?
Page number 66 of.
106, my lord.
106.
Yes, sir.
I have to say to submit your pension papers immediately. So that was given to Amar Sharma. You are a
Yes, yes.
petitioner. So in pursuance, ki boli golo? What did I say? No, asking to appear with his pension papers before the office of the
Director.
Director of Handloom and Textile, Assam. The petitioner went to the office, but his papers were not accepted on the ground that the matter is sub judice before the court.
No, not judicial proceeding, a criminal case is pending, Lordship.
Oh, it was not accepted on the ground that some criminal case is pending against the petitioner before the criminal court. It is a settled position of law that the provisional pension, pension,
My lord, my prayer is, my lord will limit to provisional pension now, my lord. Let us.
pension, it is a settled position of law that pension or in certain cases, the provisional pension cannot be denied to the petitioner, even if some cases are pending against him. As such, the office of the Director of Handloom and Textile Assam is directed to consider the pension papers of the petitioner and allow him the provisional pension in the meantime.
Well,
List this matter again on, when do you want? You have to place the records
my lord. My lord will fix the matter.
First, before petition.
on 19th of June,
19th of June.
okay?
Obliged.
Yes, the council is here, 17 to 22. But someone else was also required?
informed me he is coming.
Oh, Mr. Petitioner's counsel was not there. Okay, then we will take it up after some time. Mr. Chakraborty, you are there?
Lordship, in item 15 and
Huh.
leading is complete, Lordship.
Huh.
Matter can be fixed for hearing because it will take some time deliberation.
Ah, the petition looks very big. And
But
today
it-
there are so many matters.
Yes.
Okay,
Immediately after vacation, Lordship,
okay.
on a hearing date.
If it is before vacation, then
Before vacation on
He
it
is
here.
getting pension. He has,
Otherwise
he has received all the retirement benefits, Lordship.
Today is otherwise the hearing day, we can hear, but then there is a parted matter also.
If it can be taken fixed on 18th, let us try, Your Lordship.
18th?
18th.
Okay, next to next Thursday, Mr. Chakraborty. As prayed for by the learned councils of all the parties, list this matter for admission hearing on 18th of June.
17 to 22.
Mr. Decker, you are there?
Yes, madam.
What happened? Some affidavits are required to be filed or something? What?
I think affidavit may not be required because
Hmm.
already Honorable Division Bench has decided the matter.
Hmm.
So Lordship may look into
It can be taken up for disposal?
Yes, yes.
Miss B. Bora has filed her affidavit?
I have filed in, WPC 1479 and
842.
842-26.
Okay. 842 is before me.
Suraj Sharma and, Dipanjali Das.
And that will cover all the cases.
Lordship, similar.
Yes. Hmm?
Basically here,
Hmm.
the issue is that the persons who are contesting this petition, they are having DLED course of 18 months. So I may refer the background basically because
Yes.
it needs that background.
Hmm.
Basically, the 18 months DLED, the candidates, they were earlier in 2017, the RT Act was amended.
Hmm.
So with that amendment, all over India, there were 14 lakhs people, 14 lakhs in-service teachers were there who didn't have any DLED course or any
DLA is what?
diploma in elementary education. which is
diploma in-
basically required for upper primary and lower primary as per NCT guideline.
Hmm.
So they didn't have that. So RT Act was amended. So I have referred also here. So RT Act was amended in 2000.
RTA Act means?
Right to Education Act
Oh,
basically.
okay.
So right to, so in that case, so section 23, the amendment came into force. In that case, they said that within March 31st of March 2019, if they didn't have any qualification required under NCT, then they will have to lose their jobs.
Hmm.
It was came in
So the cutoff date is given 31st of March
2019.
2019. Okay. Hmm.
So the amendment came into force on August, my lord, August 2017.
Hmm.
So basically, DLED course is just for 2 years.
Hmm.
So from counting from August to March 19, so it was not
Not 2 years.
2 years. So they reduced it for 18 months for only for the in-service teachers who were serviced in government aided, private unaided schools, basically.
So they were given to complete their course within 18 months.
Yes. So because they were in-service teachers, so they got that benefit. These petitioners have also done that 18 months DLED course. Thereafter, what happened? The issue of DLED, whether it is valid, 18 months is valid or not, it went up to the Supreme Court. So Supreme Court decided that on 10th of August 2017, the person who were in service, they will be entitled for this benefit. So there should be a proof that on 10th of August 2017, they must be in service. So this petitioner said that we are in service on 10th of August 2017, but the respondent authority is requiring the UDIS code, basically for ascertaining their in-service position
Status.
as on 10/8/2017. So
By
now-
seeing the DIS data.
Yes. So now the claim of the petitioner is that on 2017, UDIS was not mandatory, though it was mandatory, but all the schools were not having the UDIS code. Therefore, this requiring of UDIS is bad. It's arbitrary. So in that case, similar matter in a different writ petition, it's went up to division bench, and division bench has decided.
This is the division.
Yes, first single bench has rejected the issue. Then it's went up to division bench, and division bench said, basically from it's page 78. Lordship.
Yes.
The last paragraph,
Hmm.
the learned Advocate General Assam, though initially contested the appeal and the interlocutory application on merits, but agreed that the applications of the applicants shall be verified by the state, and whatever documents as demanded by the notification dated 17/6/2025. This is our challenge basically.
This is 17/6/25 speaks of
17/6/2025 is the notification by which
DIAS data.
DIAS and other 5 documents also. If I may refer the 17/6 document in my petition at page 162, if Lordship may, I will look at that.
Hmm.
This list of
18
testimonial
months.
documents.
Who have successfully submitted their 18 months DL from NIOS is
National Institute of Open Schooling, they are
Acha.
representing.
against the advertisement are hereby asked to attend the second phase of physical document again. Notify with the following documents. Acha, okay. So they were called with certain documents.
Yes.
Huh.
So
DIAS data is one of them.
these petitioners are claiming that they have all these 5 documents
Hmm.
except that the F number document, that is UDIAS code.
Because it was not
that
maintained by
not
the school.
mandatory as per their
No, it's mandatory, but it's not maintained.
Yes.
Yes.
Though it was mandatory, but it was not maintained by all schools.
Hmm.
So in that case, this
Then.
division bench order, the applications of the, I'm reading from the top, page 79. The applications of the applicants shall be verified by the state, and whatever documents as demanded by the notification dated 17/6/2025 are not produced by the applicant.
Let me come from the
The
first
same
line.
shall be verified.
Wait
by
one
the state
second.
record.
Initially contested and but agreed. Okay. So agreed that the applications shall be verified by the state, and whatever documents as demanded dated so and so are not produced. Acha, whatever then are not produced, the same shall be verified by the state from the state
From the
record.
state archive.
And in case their applications are rejected for the reason of the same having been found to be not genuine, and the reason for rejection of it shall be intimated. Okay.
Yes. So
he agreed what? Agreed to that even if some documents are not there, they will be considered.
no, they will verify the documents from the state archive.
Okay. So if the DIAS data name in the DIAS data is not there.
If suppose hypothetically petitioner couldn't produce the UDIAS code for a particular school, then the state government from their archive, they will produce the, because they will having their document.
Yes. Okay, that will be verified.
Yes, that will be verified.
So the Advocate General agreed to that.
Yes.
Then what happened?
Then in that case, it was ordered accordingly.
Accordingly, we go along with the expectation
So
with
with that
such
caveat,
exercise.
basically, that was ordered.
Okay. So that verification will be done by the officials.
Yes, state.
Hmm.
So similar order may be passed in this case.
Oh, here also you did not fulfill F.
Yes.
It can be verified.
Yes.
Lordship, 1 point, Lordship. May I take a lordship to the last paragraph of that division bench order? Accordingly, we close this appeal along with the interlocutory applications with the expectation that such exercise, no, Lordship, before that.
In the facts and circumstance, we also modify the judgment impugned to the extent that we have resolved. No. Within a period of 3 months.
Directed to consider within a period of 3
Lordship,
months.
page number 78, last paragraph onwards.
78.
78, last paragraph
Oh,
onwards.
that's what I've just read.
Already read.
Produced by the appellant. No, there is an exception. This order is applicable only in respect of those appellants, not for others.
Those appellants.
This order is not applicable in respect of the present writ petition, because the single bench has dismissed the writ petition, imposing the
He is
cost of.
telling it as a covered order. This will also cover the instant issue.
Exactly.
Because facts are same.
The issue is also same.
This judgment will not be applicable, but it will be cover his issue.
The verification part.
You verify and then send it. Why reject it on the ground of absence of DIAS code when it is not maintained?
My lord, I can argue in on merit, but as there is a division bench order, therefore your lordship will be also somehow barred from that. Therefore,
Going
I'm
into
not arguing
the
on that.
nitty-gritties of the facts.
Yes.
Okay, Mr. P.N. Sharma.
End of NIOS limited lordships.
Okay, I'll go into those affidavits.
Because.
But just
And
show me
the
those.
end of NIS is in our favor itself. They
No,
have
no,
stated-
it is not actually favored. It is,
Impliedly favored.
maintained by the state government lordship. NIOS not maintaining the record of dice data, so it is verified by.
Oh, that is what is stated by the division bench.
My humble submission, only one submission, Lordship. here.
Yes, why one?
If we entertain again this writ petition, then because this division bench order was applicable to only those appellants.
Yes,
So if we allow.
but these are similarly
then this-
situated teachers.
This will continually go on, Lordship, otherwise. Means
But
My
you
lord- my
cannot,
lord,
there-
he-
there
you cannot
was a-
deny the
My lord, if he
assimilates.
concedes that the issue is not same, then it's very well. My lord may fix a date for
Because
disposal.
similarly situated people, you cannot deny.
Then Lordship may fix the day after tomorrow, Lordship. I will.
Nothing to have gone through all this. At last moment, a government advocate has the habit of saying at the last moment, fix it on some other date.
The
No,
only thing is that. Lordship,
no, no.
because
It's okay. I'll
then-
see whether the facts are same or not. Okay, just show me the basic facts of the case.
Yes, yes.
That they were in service candidates and all.
My lord,
I'm taking up 842.
yes, 842.
Hmm.
So basically from Annex 3, page 80, they were in service.
Hmm. How many petitioners are there?
Here,
Baapre,
58,
58.
then
They are all in service assistant
this was
teachers.
6 petitions. All
They're
total, I
working
think
in the
it's
same
104
school?
petitioner.
Acha, working in the same school or
No,
what?
no, different school, my lord.
In the one particular petition?
No, everyone is in different school.
No, no, these 58, 59 people are in different schools.
Different school. As the issue is same, therefore they have joined together and filed this petition.
Okay, right. Heard Mr. B.M. Dekra, learned counsel for the petitioners. And Mr. P.N. Sharma, learned standing counsel for elementary education. And Ms. B. Bora, R.B. Bora, for the BTC. What? No.
Five,
Yes.
NIOS,
Oh, iOS.
NIOS,
No BTC here. Respond number 5.
yes, National Institute of Open School.
For National Institute of Open School, arrayed as respondent number 5. The case of the petitioner is that they were working as assistant teachers in different schools, in different
Private school,
private schools,
yes, all are private.
in different private schools. No, you just said the petition, it is the case of the petitioners that they are holding the post of lower primary and upper primary teachers in different private schools within the state of Assam. During their tenure, what was amended? The right to education.
Yes, ma'am.
When were they appointed, from which year? During their service tenure, this amendment was brought into force.
Yes, yes.
During their service tenure, an amendment was made to the Right to Education Act.
Right of Children to Free and Compulsory Education Act, the full name.
Where is that?
At page 142.
142.
Yes.
Yes. An amendment was brought in the Right of Children to Free and Compulsory Education Act 2017.
2009.
2009 by way of an Amendment Act of 2017. Full stop. By the said amendment, where is that? Yes. By the said amendment, in section 23 of the 2009 Act. In subsection 2, no, in section 23, in section 23, subsection 2, after the proviso, this is second proviso.
Yes, second provision.
A second proviso was inserted. As provided below. Within, start inverted comma. Provided further that every teacher appointed or in position as on the 31st of March 2015 who does not possess minimum qualifications as laid down under subsection 1 within I or 1 within capital big one, within bracket, shall acquire such minimum qualifications within a period of 4 years from the date of commencement of the right of children to free and compulsory education. Amendment Act, amendment within bracket, 2017. So here it is 4 years.
My lord, date of, from the
From
date of commencement, that is
commencement.
from 2015.
That is from 2017.
No, 15. Date of commencement is first day of
Oh,
April
oh.
2015.
Full stop. They said amendment has come into force on first day of April 2015. It is provided that the teacher has to possess the minimum qualification within a period of 4 years from the said year of 2015. Okay, I'll dictate the rest of the order after 2 minutes. Okay.
Only one issue, Lordship,
Hmm.
because that division bench order was pertaining to a different recruitment process by different advertisement. And this is pertaining to a different 2025 advertisement. And that recruitment process is already over. So there is.
So advertisement means what
My
advertisement?
lord, I'm clarifying that. The challenge in the writ petition, it was in a different advertisement, regarding different advertisement. And this
Advertisement for what?
for appointment of teachers in
Teacher.
lower primary and upper primary.
That is appointment.
That is
Yes.
a
Here the minimum qualification that is
And
required.
the issue is regarding this notification 17/6/2025 that has been challenged in that advertisement case, means the in division bench matter. And here also we are challenging this. So the issue is same.
issue is same.
Advertisement is different.
But the recruitment process through advertisement, that was of 2023 advertisement. And during the pendency of that writ petition, that process was not over. Here, this is pertaining to a 2025 advertisement. And
No, I'm not able to
Yes,
understand.
yes.
Here, the thing is when they were in service,
Lordship,
they were supposed to have that degree, diploma,
Lordship,
right? And then but they have to get it within a particular period of time, 2 years.
Lordship.
And so, because that 2 years thing is not done, because by 31st of March 2019, they have to have the degree. And the amendment was actually it was made with effective from a prior date, but then the amendment was brought in like August 2017. So 2 years thing is not there. So it was made to 18 months.
Lordship.
But what has it got to do with the prior advertisement and all?
No, Lordship.
I'm not understanding. Maybe there is something I don't know.
Lordship.
No, means what he is saying that this division bench matter, it's regarding another advertisement.
Doesn't matter.
Exactly.
Here, this is
The issue
another.
is same.
The
This
issue of obtaining the
DLA degree.
DLA degree is there. The issue is that whether they can be given that benefit of verifying it from the records,
Lordship, that.
because they could not place.
Issue is not different. The
Hmm.
issue is same.
Then what is
Only
the,
thing is that, Lordship, the petitioners are claiming the appointment here pertaining to an advertisement of 2025.
Hmm.
That process is already over. That my submission may be recorded. Lordship.
It's okay.
Okay.
But where is that 2 years thing? Notification.
Yes.
Acha, acha. Okay, wait. Then this what amendment, right? Amendments was what? With effect from 2015. So 4 years. Right. Okay. Where was that? Yes, 142, right?
Yes, 142.
Although the said amendment was brought into force with effect from the first day of April 2015, but the said amendment was but the said amendment received the assent of the President on 9th of August 2017. Then what happened? This is put to challenge? No.
No, no, this was not put to challenge.
Acha, acha.
The veracity of the 18 months DLED course, that was put to challenge. It was challenged before this High Court also in Uttarakhand.
By the state? No.
No,
By
petitioners.
But 18 months, why will they challenge it?
Because they are challenging that this 18 months DLED course is not at par with the 2 years diploma in, holders. Because they are
Some other petitioners have
some other
challenged.
petitioners.
Who had 2 years.
Yes, they have challenged it. That issue went up to the Supreme Court. So Supreme Court decided in a review petition that I have annexed also here.
Hmm.
So it is at page 73. The Honorable Supreme Court has clarified it that the person who were in service as on 10th August 2017.
9th August.
No, 10th August 2017, they will be eligible for this 18 months DLED course.
Okay. The petitioner states that the Honorable Supreme Court, in the case of Vishwanath and others versus State of Uttarakhand, in review petition of 2024, in civil appeal number 7872 of 2023, by order dated 10/12/2024. No, before this, you give me those facts that after this amendment, what happened?
After this amendment, the person who were in service, they were allowed to do the DLED course of 18 months through NIOS.
18 months, where is that? 17.6.
I'm not getting 18 months.
No, that you have to do it within 18 months or 2 years. Where is that provision?
That is the amendment.
And it is in, of course, 4 years from the date of coming into force.
Yes.
But
in that case, thereafter what happened, the NCT has recognized that 18 months DLED course.
Oh, this is where?
Yes, that is at page 144.
Yes. This is what I'm asking.
Sorry, page 151.
That was in Hindi. वो जो
No,
लिखा है
it
ना,
is in English.
वो बाद में लिखना, हाँ. उसके बाद after the amendment had come into force, वो दे दिया ना. Thereafter, on 22nd of September 2017, the National Council for Teacher Education, by an order, where is that, the relevant portion of 18 months?
It is at page, second paragraph, my lord, itself. 151.
Yes, 151, second paragraph.
Yes.
Has received directions from section 19. But where is that 18 months?
It it is down below, my lord. The
Oh, yes,
provisions
yes.
are.
Huh,
Any
number two
provision
provision.
related to online submissions when so any provision related to duration of program has to
Provision related-
reduce it to 18 months instead of 2 years.
But first, that 2-year period come from the amendment.
No, 2 year,
Yes.
it was originally there in, as per NCT guideline, 2 years was there. So NCT.
No, from the amendment, it is said 4 years from the date of 2015.
Yes,
So from 2017, it will be 2 years because where is that? Where that the teacher appointed as on 31st of March 2015.
yes,
Okay, so as on 31st of March 2015, who does not possess the minimum qualification, right?
yes,
And this one has come in 2017.
yes. Amendment has come into effect on 2000, come into force on 2017, yes.
But with effect from 2015.
15,
So by 31st of March 2015,
19,
not 19, 15,
no, 19. They have to complete it
within 4 years.
within 2 years, basically, though it was from effect from 15, but practically the amendment came into force on
Yes, 17.
Yes.
That was given a retrospective effect.
That's why it was reduced to 18 months.
But 31/3/2019, where did you get that cutoff date? That they have to have the degree? You said 31st of March 2019.
My lord, my lord, 152 also, it is clarified, page 152.
Roman 6.
Page
Roman 6.
152, Roman 6.
Any provision in regulation restricting the Roman 6?
6, my lord.
Page 152.
Roman 6. 152, first 5
6,
and 6. All
And,
NIOS to operate study centers named by staff, academic and orders as per instruction of MHRD to enable NIOS to complete the training of in-service teacher numbering around 11 lakh by 30.
by 31/3/2019. By order dated वो जो दिया ना NCLT had resolved that the National Institute, what NIOS,
National Institute of Open Schooling.
Open Schooling, to operate study centers as per the instructions of MHRD, and that the NIOS is to complete the training of the in-service teacher by 31/3/2019. Since the full stop, since the amendment was promulgated on 9th of August 2017, the 2-year mandatory, the requirement of attaining the what degree, what diploma,
Diploma in
in elementary education within a period of 2 years cannot be done since the period between 10th of August 2017 to 31st of March 2019 comes to around 18 months. As such, at this clause 2, right?
Yes.
Reduce it to 18 months instead of 2 years.
Yes, madam.
And the National Council for Teacher Education by the said order dated 22nd of September 2017, was this reduced to 18 months instead of 2 years by this clause?
Yes. This is the
But see the language,
This is the recognition order for reducing that. That means 18 months course was recognized by NCT by this order.
So and so had recognized that 18 months had recognized that the diploma obtained within 18 months instead of 2 years recognized boli diya na, recognized a diploma obtained within a period of 18 months instead of 2 years.
My lord, for the, that may be added, for the in-service untrained teachers
For the in-service untrained teachers.
at elementary level working in government aided and private school.
Yes. For the untrained teachers working in government aided or in private schools. Government aided as well as in the private schools.
Unaided private school.
Unaided private schools. They said reduction in the mandatory period from 2 years to 18 months was put to challenge before the Supreme Court. And in a review petition, that will come, wo jo likha tha na? And in a review petition of 2024, in civil appeal number 7872 of 2023, wo jo aage diya tha, the Supreme Court, in the case of Vishwanath and others versus State of Uttarakhand, had clarified that 18 months diploma in elementary education from NIOS would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues, subject to the fact that the candidates were in their service on or before 10/8/2017. Para. It is an admitted position that the petitioners in the instant petition were in service as on or before 10/8/2017, for which they have annexed the appointment letters. Full stop. Thereafter, then the advertisements were issued, right?
Yes.
Thereafter, on 8/1/2025, and the advertisement B on which date?
A and B both, my lord, same day.
Acha, acha. Thereafter,
A is for lower primary and B is for upper primary.
thereafter, 2 advertisements were issued on 8/1/2025, one for upper primary and one for lower primary, for filling up of 2,900 vacancies of assistant teachers.
My lord, total 4,500. Combining.
For filling up of 4,500 posts of teachers in both upper primary and lower primary schools. The petitioners being eligible under the said advertisements applied online in the official website of the Education Department for the said post of assistant teachers. And during the selection process, by notice dated 19/11/2025, the candidates were directed to submit the details of the HSSLC, Higher Secondary School Leaving Certificate examination, and NIOS-UDISE in the official website of the Director of Elementary Education, Assam, from 21/11/2025 to 27/11/2025. It was also mentioned in a said notice that if the candidates fail to submit the details of the DIAS code or wrong DIAS code is submitted within the stipulated time, their candidature will be cancelled. This full stop. The submissions of The submissions of the particulars were however later on extended till 1/12/2025. In response to the said notices, the petitioners stated that they have submitted the details, both in respect of examination and in Dias code. But then they have given Dias code, then what?
They have given, but the government is saying that they couldn't find out.
Acha.
It's this.
Hmm.
But they have verbally stated that they couldn't find out. They have not issued any notice or order. So they have outrightly rejected the candidature of the petitioner.
The petitioners, however, submits that on submission of their candidature, they did not have the diploma in elementary education. No, no. Their appointments were given.
Yes,
Huh.
they were having 18 months DLL.
And when they were in service, they had done it. But Dias code, what happened?
Dias code also there, but in some schools, in some private schools, they have obtained the Dias code. Suppose not in 2017, they have obtained in 2020. Someone has
Acha.
obtained in 20.
But otherwise, after this advertisement, they were all appointed.
Yes.
ये इसके पहले लिखो. हाँ. That the petitioners, by virtue of the selection process, were appointed as teachers in different schools.
But their dice codes were not clear, and there is a doubtful about the dice code. That is why.
But then they were appointed.
No, their appointments were earlier, not in terms of this advertisement. They were already working, but insofar as this recruitment process is concerned, their eligibility will be there only when the dice code is there against their name.
Now, this will come when they were in service.
Now, Lordship, for applying in.
My lord, may I clarify? In 2017, they were in service. They were in service in private schools. Now, in that duration, they have done the DLED course for 18 months. Thereafter, they have completed it by 31st of March 2019. Thereafter, on 8th of January 2026.
No, first of all, let me know. I mean, they were working after the advertisements of 2025, right?
No. Oh, yes, they have been continuing it. They have been continuing from 2017 itself.
Now, what about this advertisement A and B?
Thereafter, their
A and B advertisements.
candidature has been rejected. They were not appointed.
They were not in the
They were
government.
not
Acha,
appointed.
before these advertisements, they were working in different schools.
Different
Yes.
private schools.
Those facts were not placed right.
Lordship.
So,
different private schools.
they
Now
were-
they are applying for the government schools.
Now they are applying in government.
While advertisement dated 8/1/2025, they have applied it. So after application, they issued this order of 1911.
Tell me the facts in chronological manner.
Yes,
They were working in private schools, vagera,
Yes.
as assistant teachers, right?
Yes.
And then they saw these advertisements and they had applied.
Yes, they have applied it as they have obtained all the eligibility criteria as per the advertisement. They have applied it. Thereafter, after applying it. by
No,
or-
no, not after applying.
After applying, my lord.
In 2025.
Yes.
Okay.
After they have made it online application. So thereafter on 9.
Then they had obtained a diploma
They have obtained earlier itself in 2019
when
itself.
they were in service in
Yes,
other
yes,
schools.
Yes. They have obtained that degree in 2019 itself by 31st.
18 months DLED.
18 months they left.
18 months.
Acha, this chronology has to be changed. Before this advertisement, लिखना पड़ेगा. The petitioners were working. वो जो लिखा है ना, they were working in different schools. उसके बाद दे देना, हाँ. That while they were in service, right?
Yes.
While they were in service, they had obtained the diploma, but then the chronology will be changed. They had obtained the diploma in elementary education
Yes.
pursuant to the amendment.
Yes.
Pursuant to the amendment in the Right to Children Education Act
From NIOS.
from NIOS.
18 months.
By
18 months.
18 months diploma.
yes, 18 months diploma. You type it out, I'll make it sequence wise. They said a reduction of the mandatory 2-year course to 18 months course were put to challenge before the Honorable Supreme Court. And Supreme Court, by order dated this one, Vishwanath, had said that the 18 months vote to diya hai na, 18 months thing is valid. Okay.
My lord, in that case, one correction, that civil appeal number 7873, that was not 7872, it was wrong.
Okay, 7873 kar dena, huh? So that was said to be valid. After that, you talk about the advertisements. Right. Then after the advertisements were issued A and B, and then they applied for the same. And they had given the DIAS data as well as HSSLC.
As per the notification dated 19/11/2025, after issuing this notification 19/11/2025, whereby they were directed to produce that document, they have produced it.
They have produced it,
Yes.
right?
So it is at page 1 from 132, my lord.
27/11/25.
Yes.
27/11/25 का बोला है तो then duly submitted वो जो बोला है ना duly submitted the details of HSLC and DIAS code, then it was not accepted. They could not be.
Whether it was accepted or not, we do not have that knowledge, because they have outrightly rejected our candidature, because in the main final select list our name was not there. Though our cutoff mark is more than the other petitioners who were selected.
Doesn't matter, but then your DIAS code did not match.
That might be the reason.
But however, the petitioners were not appointed pursuant to the said selection process. So what happened after that?
My lord, thereafter on 27/1/2026, physical document verification was done. For first phase, second phase on 22/26.
It is further stated by the petitioner. That their candidature was rejected.
So
No, they do not know the grounds.
yes. So whenever they have approached the office, we have written here, they have approached the office, then they said that you do not have the proper UDIS code, that's why your name has not been included.
And they were not appointed, bola na. And the petitioner further states that they approached the office to get the reason for their cancellation, for the rejection of their candidature, and they were informed they did not possess the UDIS code. That they worked in the school which did not have the UDIS code.
As on 10/8/2017.
As on 10/8/2017. Then this one will come.
My lord, thereafter physical document verification was done.
Where is that? Where is the pleading to that effect?
It is at page 163. From page 163 to 165.
उसके पहले लिखो. Thereafter, on 27/1/2026, physical documents verification was done. But after that, they went to office and came to know that it was rejected because of absence of DIAS code. लिख के रखो, I'll finalize it. On 27/1/2026, physical document.
Sorry, my lord. On 27/1/2026, first physical verification done. Then on 2/2/26, second verification done. Then also, as their names were left out from that list, so on 12 of February, they have approached the office.
Physical document verification was done. And on 2nd of February 2026, also certain verifications were done.
And on third phase, on 10/2/2026 also.
as well as on 10th of February 2026. And after that, when they did not find their names in the select list, they went and inquired in the office of the elementary education, wherein they were informed that the school they worked did not have the DIAS code, DIAS code,
Yes.
the DISC code. Then,
Thereafter, my lord, on 12/2, they have approached, 12 February, they have approached the office. They said that thereafter, the petitioner approached this honorable court by filing a writ petition, this present writ petition 842, my lord. And on 18 February 2026, an order was passed issuing notice. If your lordship may take up writ petition 1519, lordship will get that order because it
no,
was
let us,
subsequently passed.
already things are confused. So, let us see this.
Yes,
So what happened on 18th of February 26, notices were issued.
yes.
Then you have challenged your non-inclusion in the select
Yes,
list.
yes. Yeah, given case of- Oh, no, like-
Yes, Mr. Das, NC Das, it will take some time. What is your matter? Item number? 29. You can come. Otherwise, I have one parted hearing matter which I'll take it up at 2. So, 29, 29 after that, and few advocates have also mentioned their matters to be taken up at 2. So, you keep your junior here and we will inform and then you can come.
Problem.
Yes. Then,
Then on
no, I
18
want, yes,
On 18/2, notice was issued in the present writ petition, that is on 8/4/2. So in that case, it was also further directed, my lord. At page 7, I'm reading, considering the
So,
nature
the
of the
pehle
dispute
wala
arising in the
paragraph-
present
pehle
proceeding,
wala
the school is
paragraph
of the considered view that an interim direction restraining the respondents from proceeding with the recruitment exercise would not be called for. However, it is provided that any appointment made in pursuance to the said advertisement, both dated 8/1/2025, shall be subject to the outcome of the
Okay,
present
okay,
writ petition.
subject to the outcome,
The
okay.
said aspect, further, the said aspect of the matter shall be reflected in the appointment orders that would be issued to the selected candidates. But they have violated it. They have not reflected that this
Indeed.
order. my lord.
Hey, that will again scare those
Yes,
candidates,
yes, but
okay.
I'm not going to that.
That will scare the candidates. It's okay, outcome of the repetition, they'll have to induct you somewhere.
Yes, yes. As vacancies are there already. I've been told that 900 vacancies are there.
Acha, what have you challenged with which notice? 19/11/2025 is where?
At page 130.
Acha, this notice only, where they were asked to
Yes, and the notification is the.
and the other notice is 27/1? Where is that?
That is for extension only. That is in the next page.
Acha,
But the
acha.
main notification is just 17/6/2025, which is the issue basically. That is at page 162.
But you have not challenged this 17/6?
My lord, I have not challenged in this writ petition. For the other writ petition, I have challenged it. In the other 5 writ petitions. Basically, the issue comes from that. Though
17/6 is where?
At page 162.
162.
Earlier, I didn't challenge because I had all the other documents
But this advertisement is different.
different.
This is
But they are applying this notification while they have issued the physical document verification.
They have applied this notification when they had done the physical verification.
Yes, if your lordship ever look at the next page, page 163,
Where is that? Notification dated 17/6. So 17.
sorry, 27/1.
27/1, yes. Where is that? That this
Important points of verification. So the NIS candidate
17 June, okay, yes.
So it is the.
This is applied.
Yes, that is.
ओके हाँ फिर अच्छा पहले वाला पैराग्राफ में लिखा है देखो एकदम पहले वाला पैराग्राफ पढ़ो तो उसके बाद अच्छा अच्छा उसके पहले इट इज द केस ऑफ द पिटिशनर के पहले एक पैराग्राफ लिखो बाय दिस एप्लीकेशन filed under Article 226 of the Constitution of India, the petitioner has challenged the impugned notice dated 19/11/2025, as well as the subsequent notice dated 27/11/2025, by which the petitioners were directed to submit details of HSSLC examination, as well as the NIOS-U DISE code or what? DISE. DISE, huh? Full stop. The petitioner has also prayed for a direction to the respondent authorities to refrain from applying the UDIS as a proof of in-service as on 10/8/2017. The date. It is not. Why 10/8? Why not 9/8?
Because Supreme Court has clarified it as on the 10/8.
That is.
From the next date. They have counted.
That is the next date from which the amended act, the amendment to Right to Children, वो जो पूरा act है ना, Right to Children
to
Act
free and compulsory education.
was notified. The petitioner has also prayed to appoint the petitioners as teachers against the total 4,500 posts in LP and UP schools, as per advertisement dated 8/1/2025. अच्छा अब last में जाओ, what was that?
Lord, one clarification. In other writ petition, we have challenged that 17/6 notification also.
Okay, there I'll dictate. Last में क्या है? They went in and then they were informed. So after that, what the Supreme Court that I have said, right? And then 18 months is sufficient. So only you are agree with the Dias Court rather.
Basically that. You asked for.
So how can this judgment be applicable to you? I forgot. I mean,
Yes.
huh? Which paragraph you submitted?
Yes.
Oh, acha.
Page 78, madam. From page 78.
Okay, huh. Para. The learned counsel for the petitioner submits that similarly situated teachers had approached this court by filing what writ petition? By filing writ petition being WPC number? It is not referred in the appeal also?
Earlier, the 3794 of
Yes,
2025.
it is referred.
3794.
3794 of 2025.
Where did you get it?
Page 76, madam.
76. 3794 of 2025. Wherein similar prayer was made. That demand for additional documents for verification was arbitrary, and it was violative of Article 14, 16, and 21 of the Constitution of India. In the instant case also, the petitioners were asked to submit their UDIS along with the details of examinations. The learned single judge in writ petition number 3794 of 2025 had done what? Have you annexed the order of writ petition?
No, I have not annexed.
That has been
So
dismissed.
that was rejected.
That was dismissed with cost.
Acha.
Yes.
The learned single judge had dismissed. Oh, क्या बोला क्या बोला? Had dismissed the said writ petition. And the petitioners filed an appeal before the intra-court appeal before the Honorable Division Bench of this court. And the Division Bench, wide order dated 24/6/2026,
24/3.
24/3/2026, on the basis of the submissions made by the Advocate General Division Bench had taken note of the submissions made by the Advocate General
78 last paragraph onwards.
that applications of the appellants in that case shall be verified by the state and whatever documents demanded by notification dated 17/6/2025 if not produced by the appellants, the same will not be fatal, and that the authorities would verify the said information from the state records database full stop. Where is 76 notification here? Which page you said? 17/6?
Not at page
Oh, yes, 162.
162, my lord.
The notification dated 17/6/2025. It be stated here that notification dated 17/6/2025 was issued by the Director of Elementary Education, Assam, notifying that the candidates who had applied their online applications with 18 months diploma in elementary education from NIOS against advertisement dated 26/12/2023 were asked to attend the physical document verification test. Verification. By carrying certain documents mentioned in the said notification. And one of the document that was asked for was the UDIS record as a proof that the applicant was in service as on 10/8/2017.
Also one verification here. This notification of 17/6/2025 was issued in compliance to the
Supreme Court judgment,
that
yes.
line may be hidden. Because
Yes.
this notification was issued in terms of the judgment of the Supreme Court in the.
Further, it be stated that the said notification was issued in terms of the Supreme Court judgment as mentioned above. In the instant case also, while calling the petitioners for physical verification, for document verification, the said notification was applied. That is notification dated 17/6/2025. Full stop. The Honorable Division Bench what is the final finding?
Basically, at page 79, the second paragraph.
79 second paragraph, Lordship.
The Honorable Division Bench, with the undertaking given, with such undertaking by the Iman, we consider this appeal ought to be closed, sustaining the judgment, implementing this appeal. The Honorable Division Bench held that the state would verify the documents furnished by the petitioners. And if some documents are not found, as per the notification dated 17/6/2025, the same will be verified from the state records database. Full stop.
And in the event of rejection, Lordship, that.
Yes, in the event of, okay. A full stop, it is further observed that in the event of rejection of their applications, the applicants shall be communicated about the reasons of such rejection. Para. In the instant case, it is seen that for lack of UDIS code, the petitioners were not appointed in pursuance to the advertisement. That is advertisement A and B. Published on
8 January 20.
8 January 2025. It is stated by the learned counsel for the petitioner that maintaining the UDIS code with NIOS is a mandatory requirement. But some schools had not maintained it. But the same
Maintaining
is
of UDAS with the state government.
with state government. And what about Delhi? Some Delhi also.
Basically, it is by the Sarva Shiksha Abhiyan Mission, that is UDIS. It is maintained in Delhi.
Delhi,
It is
yes.
unified.
So UDIS with state
Yes.
has not maintained it. Although the said registration is otherwise done. The DIAS data is not maintained, but then school has registered,
Yes.
or what?
No, Lordship. That school has to apply for the DIAS data with the concerned authority, Sarva Shiksha Abhiyan, which of course under the Assam for the state. So they have to apply. And
So
if
they have not applied.
they have not
But then
applied,
how
and
can-
their DIAS data was not
Here the
available.
question is whether we have applied or not. Our school authority is applied or not. That is the.
Yes,
that is not the
principal will
issue.
do it,
That is
headmaster.
not the issue.
Because the process
The-
is that.
the
Process
issue-
is that the school
Yes.
has to apply for the use data.
Basically, our
And
claim,
upon verification of the infrastructure and everything.
Now that they have not,
basically our claim is that on 10th August 2017, the UDIS was not though mandatory, it was not having by all the schools. So therefore, the requirement of UDIS cannot be made as mandatory. That is our claim.
but what will they find out in the state records?
If they find out, then okay, my lord.
If they have applied.
If you have not applied, there's no question of finding out.
there will
My
be-
lord,
there will be-
later on they have applied. Suppose some schools have obtained earlier also. Some schools
So
have
let them
obtained later.
verify. If
Yes,
it's
let
not
them
there, then.
verify.
That is basically for verification also.
Okay, Kikolo, what did I say? No, again, no, we should forget it. It is not maintained by the schools. As such, the as such, the asking for such document from the petitioners is challenged in the instant writ petition. However, the petitioner, the state authorities can verify from the records as to whether the said exercise has been undertaken by the said school in view of the in view of the conclusions reached in writ appeal number 345 of 2025. I'll change in between those things. And if the record shows that the petitioners were in-service candidates and who have completed 18 months diploma in elementary education and the school where they were working. It is Dias data is only that there was a school, existence of the school, right?
Yes.
So if they can find out that there is
Existence of this lordship, basically this here the eligibility of that 18 months DLED course, that is the issue here. Therefore, that eligibility of 18 months DLED course is to be verified.
not only that, but also Dias code, the recognition of the
Lordship-
school.
Lordship, that is why for that Dias data has to be verified. That's
Whether,
what has to-
whether
whether
that
they-
school was there at
having
that
that-
particular time, whether the person was in service at that
This
time.
is what they can verify it even without Dias code.
Yes.
No, Dias code has to.
Not maintained by so many private schools, right?
Lordship, Dias data is like Aadhaar card for us. Identification of a school.
And this is what.
Identification of a teacher working in a school.
Yes,
That
this is
the
what.
only,
But if the Dias
the
code is not,
information-
they did not
Dias-
maintain.
Dias means District Information System for Education.
Yes,
So
but if they
every
do not,
information will
My
be
lord,
there in the Dias.
there are
No,
orders,
without-
there are orders from the respondent authority itself that they are not having, all the schools are not having the UDS code till today also.
so, okay, UDAS code they don't have, they did not register.
To be eligible
But
to.
for that, the teachers, these petitioners, who were in fact in service.
No,
And
in
who are
service in
eligible
a
also.
private school, Lordship, not in service in a government school.
Yes, in
Because they
private,
were- they
government
have-
aided.
In fact, they have applied in terms of this advertisement.
Okay, he will not stop. Okay, fine. Verify the.
I'm sorry.
I'm telling you one simple thing. That okay, they were working in private school, but they were working. Dias code was not maintained. For that, they should not be penalized for rejecting their
Exactly.
candidature. Technically, you are correct. But imagine, technically, I'm okay.
But to be eligible, Dias code is necessary.
That is what, that is known by all. But then they should not suffer. So let them verify the existence of the school, right? And that they were in
petition can
service.
Be appointed.
No, they
And then they will consider them
Yes,
for
they
appointment.
will consider.
but
rejected
क्या
them.
बोला? हाँ. Of diploma in elementary education and and the school existed where they had worked as teachers, the state authorities will consider the appointment of the petitioners to the UPLP schools as advertised. As advertised, advertised dated
8/1/2025.
8/1/2025. As per law, though, they will not be appointed. It's okay. They will verify and consider. It's okay.
Consider for appointment.
Consider for appointment, I've told them, consider for appointment as teachers in UP primary.
And that exercise may be completed within a.
And the exercise may be completed within a period of 2 months from the date of receipt of this order.
Possibly.
Acha, what about the other petition?
Similar prayer, same.
My submission may be recorded.
Oh, yes,
Paragraph
Mr.
6, 7,
I have not recorded anybody's submission. I've just dictated the order.
Paragraph 6, 7, and 8.
Okay, I'll
In
write
the
that.
affidavit.
6, 7, and 8 of RB Bora, huh? I'll just.
NIOS.
And my submission was that this 17/6/2025 notification was issued in terms.
अच्छा वो बाद में बीच में लिख देंगे. Mr. P.N. Sharma, Learned Counsel for Elementary Education, submitted that.
Number one is that notification of 17/6/2025 was issued in terms of the Supreme Court's judgment in the review petition.
That's okay.
Now, secondly, the process which is that advertisement was issued in 2023 against that division bench order. So that recruitment process is different. Here in the present case, the recruitment process is up 2000, in terms
Oh,
of
it's okay.
2025. And that recruitment process is already over,
Mm.
according to my information. That will be recorded.
Okay, he submits that the notice dated 17th of June 2025 is issued pursuant to the Honorable Supreme Court's order in review petition as mentioned above. He also submits that the recruitment process for which the Honorable Division Bench has then rendered the judgment
Lordship.
is different from the recruitment process conducted in the instant case.
Lordship.
Okay? Mr. Miss,
In the present writ petition, that recruitment process is already over.
and that the recruitment, but then there is an interim order to bring it outcome, and that the recruitment process initiated by advertisement of 2025 has ended. Miss R.B. Bora, Learned Counsel for the NIOS, submits that. Tell me.
Lordship, we are only providing the diploma and verification. All the process has been initiated by the state government, Lordship. That is our main state, Lordship.
Where is that? What paragraph you said?
Paragraph 6, Lordship. The state verification, paragraph 6, Lordship.
Submits that the entire process of
Ah.
diploma
69.
in elementary education registration was conducted through online mode.
Online mode,
It
only
was-
the candidates were mandatorily required to carefully peruse the.
And then
detailed guideline
on careful
procedure.
perusal of the guidelines issued by the NIOS, the students has to apply.
And the particulars and credentials furnished by each candidate were subject to due verification by the concerned.
And also
principal
that the testimonials submitted by the candidates was to be verified by
concerned principal of the respective institution.
verified by the concerned principal of the respective institutions, private institution.
Yes,
Yes.
yes, yes.
By the principals of the institutions. Okay. That's
The-
all?
The said verification process was carried out under the overall supervision of the supervision and monitoring of the state nodal officer who has been duly.
And the verification of which has to be under the control of the nodal officer. Where
state
did you
nodal
write?
Officer who had been duly appointed by the state government for the.
Who has been
said
appointed by the
purpose.
state government.
Yes.
Okay?
But I think that has been noted, that the exercise has been completed, has to be
Yes,
completed
within 2 months. And what about the other matters? If their 17.6 notification is challenged,
This can be a common order, my lord. This will cover all the petition. my lord.
can be.
Yes.
Okay. So disposed of how many from
Six.
16 to 22
17.
or 17 to
17.
22?
7.
Okay.
That's all.
Deep level, Lord.
Yes.
May I pray that item number 45 be taken up on a different date, Lordship? Maybe June 17th.
45 will not even reach, I think. 45. Supply 45. Okay. Learned Counsel for the petitioner submits that the instant matter may be taken up on a later date. Prayer is allowed. List this matter on
17 June, Lordship.
17th of June, Wednesday, 18th of June, 2026.
Lordship has fixed for item 47 at 2.
I forgot. At 2. But at 2, I'll hear that Pathar, Mr. I. Bhattakur will come. Yes. At 2, I'll finish that after that.
In fact,
You tell the council, huh, Mr. M. Datta,
Lordship. Okay.
after finishing this matter.
In fact, I have received the record, but I couldn't go through it.
Acha, you will take time.
Lordship, I would have. Otherwise, I have to take consent from.
Okay, let Mr. M. Datta come.
Lordship.
Yes, Mr. Sinha, you were waiting for?
Item number 46, my lord. Let after lunch, my lord. Not to disturb you.
We'll try that,
Yes.
Mr. Chetri.
Yes, my lord, I'm for the respondent number 3. I have also matter, I'll be standing in court number 1.
46,
That's fine. That
after
will
lunch, my lord.
After
Immediate
lunch,
after lunch.
it will take some time, after 3 o'clock.
After 3 o'clock,
Mhm.
Lordship, I'll be
After lunch.
obliged.
It's okay.
After lunch at 2 o'clock,
Whenever you are here, I'll take it up.
Lordship, highly obliged.
Okay.
Highly obliged.
27. It is some other day, my lord.
It's okay. I'm in midst of a Pathar matter also.
Matter. So-
So 26, 27.
My lord, any date, my lord.
Okay.
Okay.
26, 27 और लिखा Mr. A. Chutia, Mr.
Resputia.
The Learned Counsel for the petitioner submits that the matter may be taken up on a later date. Prayer is allowed? List this matter? Jay Chutiya, huh? List this matter on what date?
Any date, my lord.
After the vacation or
After
before?
vacation,
After vacation. List this matter on 28th of July,
Ma'am.
20. No, I'll take up hearing matters, don't worry.
Yes, yes.
This will not take much long. Yes, Mr. P. N. Sharma?
5 minutes time I'll take it because I'll be standing on my legs in Chief Justice. Court.
Oh, it's okay. I told you na in the morning that whenever you come, I'll take it up.
Yes, they are on.
Also, item number 47, Lordship.
Huh.
I have already taken consent from the Lord Senior Counsel for the petitioner Lordship.
Huh.
So he has consented and he is agreed for 10th of June. Can it be
Achha.
possible? on
Mr.
10th?
Datta, you have said.
Lordship, Lordship.
Okay, as prayed for by Mr. P. N. Sharma, Learned Standing Council for Elementary Education, list this matter on
10th.
10th of June.
Lordship,
Yes, 10th of June.
Lordship. Much
Not your matter. This is another one. Yes.
problem.
Yes. Yes, Ms. Sharma?
Item 29 hearing.
29.
That's are also there,
Huh.
sitting in. Time may not.
29. So some other day, okay?
Yes.
Oh, Mr. NC Das was here.
Yes, yes. I will inform sir.
Uh-huh. But I have some time to. This will take, I think, half an hour or so. If it reaches,
Tuesday.
Acha, okay. As prayed for by Mr. Santana Sharma, Learned,
Department Council.
Learned Standing Council for Health Department, list this matter on, on what date?
9th, Lord.
On 9th of June.
Can it be taken up at two Lordship? Because here Lordship, she has completed her Lordship medical course in the year 2016.
Acha.
And since then,
Okay, okay. One of your junior can make a prayer. I'll remember, and at 2 o'clock I will take. Mr. Azad Ahmed, A. Ahmed is present, huh? And for the petitioner. Okay.
May I please your lordship, item 47, can you please?
47, yes, he said. Mr. P. N. Sharma mentioned. So that is fixed on 10th of June,
Thank
coming Wednesday. 42 Jogaلی to Yes. Yes, Mr. Bothakur. Junior Bothakur. Yes. Yesterday, Mr. Shantanu Bothakur has finished.
Yes,
So you know what? He had not gone into the merits.
yes, ma'am.
He is only on the procedure of the inquiry.
Before I begin with my oral submission, I have prepared a written argument of.
Okay, okay, fine. Diyoksunda, Amanda. এইটো একচুয়ালি হেৰিয়ে লৈছিলে এতিয়া অকণ টাইম লাগিব দৰঠিক কালি দিছিলো যে এইটো হা yes yes of course
Then, my lord, the first contention that is raised, my lord, that the charges are vague and definite, my lord. First of all, my lord, this ground is not raised in the writ petition, my lord. It is not there in the pleadings.
Achha.
So, my lord, I will have to point out saying that this is an afterthought because it is not a part of the pleadings, my lord.
Okay.
Then, my lord, may come to paragraph 8 of the writ petition, my lord. This is what they said. After receiving the show cause, this is their statement, my lord.
Achha. Okay, if Mr. Shantanu Bothakur wants to reply, you can apprise him of whatever he has stated. Today only, huh? Okay. So paragraph 8 of the writ petition.
Yes, my lord. This is their contention about the show cause notice.
Huh.
That against the show cause notice dated 8/7/2019, the petitioner filed his written reply on 1/8/2019 before the respondent number 2, clarifying his position that he is not responsible for misappropriation of government money. Further, the petitioner has brought to the notice of respondent number 2 that he was not given any opportunity to inspect all documents. As such, notice issued on is so and so is violative of principle of natural justice. So no ground of vagueness of charge. The petitioner understood the charge and petitioner, my lord, replied to it also, my lord. In support of that contention, my lord, I have a judgment.
You have mentioned paragraph 8 here.
In paragraph 8, my lord, they have not mentioned whether it is.
No, whether you have mentioned paragraph 8 in your written submission.
Yes, my lord.
Achha. So this is on no pleadings.
No pleadings, my lord.
Acha, what is this judgment about? Biko Lorry Limited?
Yes, my lord. If
Hmm.
I may take your lordship to relevant paragraph,
Hmm.
it is also about, my lord, dismissal of an employee, my lord.
Acha.
It starts from relevant part, my lord, paragraph 30.
30.
30, my lord.
Okay, I'll read it. But Mr. Bhattakur, it's a law point rather, law
It is
point.
law point.
Pleadings may not be required.
Yes.
And if you see the charges
Yes.
as well as the statement of allegations,
Yes.
there of course no particulars are given. It's not in details. It's simply, it has said that you have misappropriated.
But my lord, the account holders' names are mentioned. My lord may see the inquiry report.
That is there. He diverted the money.
Which accounts it was diverted, my lord. Whether he became the ultimate
That
beneficiary.
is not there in the show cause.
Yes.
See, that is there in the inquiry report. But in the show cause and allegations, it's not there. Show cause is page.
So, here, my lord, the charge is given, my lord. Page 36 is the show cause, my lord.
You see, there is only one paragraph, huh? Hereby to show cause, this first paragraph you can leave.
Yes.
Second, that while you were serving as junior engineer at so-and-so,
Yes.
you did a massive misappropriation of government money
Yes.
under SBM Tinsukia division, due to which objective of Swachh Bharat mission has
Yes.
suffered, which violates Rule 3. Only this.
So, mission is, my lord, mentioned. Appropriation is mentioned. Other things are, my lord, subject to result of the inquiry, my lord. At the show cause stage itself, it cannot be expected that all.
At least that you had diverted the money from the NGOs to some private individuals. At least those
Yes.
basic informations.
Subsequently, that was incorporated in the inquiry report and the.
Inquiry report
Yes.
is there. And what about statement of allegation? I think it's in your affidavit. Where is statement of allegations? Yesterday he showed it. There is a
Statement of allegation, lordship will find at page 80.
Huh?
Page 80 of the affidavit in opposition.
It was not in his petition. 80.
80. Statement of
Yes, statement of allegation.
allegation
Page
also,
number
my lord,
80 will
mentions.
it was, that is important. Kali bisai na palo.
Yes.
Yes, here also you see,
Yes.
you did a serious misappropriation of government money under your, which are meant for implementation of Swachh Bharat, due to which objective of so-and-so suffered, which violates same. You are therefore charged with corruption and misappropriation of government money, serious dereliction.
Yes. So, my
Nothing more than that.
misappropriation and the relevant project mission is there, my lord.
Mission is
Beyond
there.
that, my lord, is subject to details of the inquiry report. And my lord, which was supplied to the petitioner. And petitioner, my lord, was given multiple opportunities to appear. Not one opportunity was availed by the petitioner, my lord, to appear before the inquiry officer. And the judgment, my lord, that I just handed over, para 30 in sum and substance says, when the petitioner is able to reply to that show cause, it is enough to show that the charges are specific and definite, my lord. It may not be elaborate, my lord, but it is specific.
The requirement is that he should understand.
He should understand.
Understood.
And my lord will see the reply of the petitioner.
Next page,
37, my lord.
Next page, yes.
Paragraph 2 at 32 will show, my lord, with an elaborate explanation, my lord, petitioner has been able to reply to the charges, my lord. So, my lord, it cannot be said that charges are vague and indefinite. And again, coming back to the first point, it is not even part of the pleadings of the writ petition.
Yes.
Thereafter, regarding the contention that petitioner was sought for documents, but documents, my lord, were not were denied. Here again, my lord, I would like to fall back on the show cause notice.
Yes, of course, that is
So cause
convincing.
notice, Lordship had already pointed out
Hmm.
yesterday that he
Hmm.
was asked
Yeah,
to
asked.
inspect the document. In his reply, he has, my lord, merely just denied the charges, but my lord will see in his reply
Last paragraph, he asks for the documents.
only, my lord, a vague statement that
Page 44, the undersigned
Yes.
did not submit effective and firm because he was not provided with the opportunity to inspect the
Yes.
documents.
now, my lord, which document, what document, and most importantly, he was supposed to write as per the show cause within 7 days, which documents he wants to
That he
see.
did not.
Yes, he did not, my lord. After almost a month, only this and a vague, my lord, contention that no documents have been given. For that also, my lord, same judgment, there is an observation in paragraph 33.
Yes.
Paragraph 33, my lord. It is, however, a very well accepted principle that supply of the adverse material need not be, unless the law otherwise provides, in its original form, and it is sufficient if the summary of the contents of the material is supplied, provided it is not misleading. Thus, what is essentially substantial fairness, and this may in many situations be adequately addressed and achieved by telling the affected party the substance of the case that has to be made without precisely discussing the precise evidence or the sources of information, ma'am.
But this is in case of adverse material, which is not required to be
Yes.
furnished.
So that is, my lord, linked to test of prejudice. Petitioner has to demonstrate that which document was not supplied and what prejudice was caused to such non-supplying of documents. That is
That
all
he has not.
missing, my lord. Missing from the reply and missing from the pleadings as well. Then, my lord, there was a contention that there was no witness in this case. So, my lord, the inquiry was not done as per law. My lord may appreciate that there are two inquiry reports. In our affidavit in opposition,
Acha, there were second show cause notice, right?
the second show cause notice is also there, ma'am.
So where is that?
That is at
Which he said he did not receive.
second show cause is not there, but my lord, the inquiry report was forwarded to him saying
that is there.
yes,
It was given to
saying
him.
if you want to submit your written statement to this, you can submit your written statement against the inquiry report. So that can very well be treated as the second show cause. Why the inquiry report should not be accepted? That was given to the petitioner, and the petitioner's reply is again at page 52 of the affidavit, ma'am.
No, where did I see that second show cause? Mr. Botaku, you had shown me yesterday. There was a second show cause.
No, not second so called. That's a letter asking him to appear, your lordship, before the inquiry authority. Your lordship will get it.
Which you did not receive.
Which I did not receive. Your lordship.
This is in the impugned order. Or what?
That is in the inquiry report. Your
Oh,
lordship will
inquiry.
kindly come to page 58.
Yes, yes. This is what. 2622 you did not
I
receive.
have not received.
Okay. Yes.
But I have stated in my reply to this inquiry report, your lordship.
Okay. You will reply after he finishes.
Lordship.
So you said there were two inquiry reports.
Yes, ma'am. One
Where is the
at
second
page 90, my lord.
90. Yes.
91 is the, my lord, relevant portion. 91, my lord, may come to paragraph 10. The joint signatories of
There are two. That first inquiry report was of which date?
first was of
Page?
first is, my lord, 90, then followed by
First is which page?
first is page 90.
90.
90.
No. This
That-
is, no, the inquiry report that we had seen yesterday.
That is, my lord, followed by at 105.
Oh, this
That
is
is what your
58.
lordship said, yes.
So submission of inquiry report in respect of so and so. I have the honor to submit here with the inquiry report. So this inquiry report is what? This is dated
The
This
first
is
one is
dated
dated
perhaps
2/9/2019,
13/3/2000,
and the next one is 13/3/2023.
13/3/23.
23.
The one that he has referred yesterday. And this is prior to that.
Prior to that.
2/9/2019. One second. And reply that show cause notice was of 8 July 2019. A1/8/2019. So after his reply on 1/8/2019,
Yes.
this inquiry report.
2/9/2019.
So how can there be two inquiry reports?
Right. This is a preliminary one submitted to the deputy commissioner, my lord.
This is a preliminary inquiry.
Yes.
Where is the order of the deputy commissioner to hold an inquiry against him? Acha, this will show cause. Hmm. June 2019. 19 June.
That
Before
order
show
is-
cause. Before show cause, DC had directed for an inquiry. So preliminary inquiry.
Preliminary.
After that, show cause was
After
issued.
that, yes.
Okay, so V. Pankaj Bora, ACA's election officer, Nabojyoti Gogoi, FSS treasury officer, caused an inquiry.
Yes.
Okay, yes.
Then, my lord, we'll see at page 91.10.
Hmm.
Joint signatories of so-and-so bank accounts will call to appear before the inquiry officers and submit their written statements. Only 5 such signatories, namely so-and-so, at the bottom, my lord, before appear before the inquiry officer. Attendance sheet and their statements are enclosed. Then 11, my lord.
But this is this will not be an answer to your absence of witnesses. This is a preliminary inquiry, not under Rule 9 inquiry.
Connection with this.
Yes, but nevertheless, because the contention is that it is based on no witness, my contention, my lord, is that there were witnesses.
But that was a
Even though they were
preliminary-
not part of the main inquiry, there were witnesses.
Mhm.
And 11, my lord, the petitioner was also called, but on repeated
Yes.
instances, the petitioner was not present.
Hmm. Hmm. Okay.
Thereafter, my lord, several are at page 105,
Hmm.
the main inquiry report, my lord, will see.
Hmm.
At
Yes.
the very top, again, petitioner was asked to attend the office on 31/5/2022, but he informed he could not attend. Then again on 2/6/2022, also the petitioner did not attend. So,
This he did not receive his.
so not one out of 4 dates, petitioner did not appear in even one of them. my lord.
Hmm. But what is your answer to this, that it was based on the records of the executive engineer? The entire inquiry report was on the basis of the report of the executive.
Yes, and in the preliminary inquiry, the executive engineer's statement was also taken. My lord will see that.
Hmm. But where is the requirement that there has to be a preliminary inquiry under the discipline and appeal rules?
Discipline and appeal rules, my lord, do not mention any preliminary inquiry as such,
Hmm.
but inquiries regarding an event of misappropriation, well, multiple delinquents could be involved, my lord. That is a routine practice that happens first to ascertain what happened exactly. Then, my lord, it is followed, and specifically, my lord, the officers are show cause. And because the petitioner failed to appear, ultimately, inquiry officer was, my lord,
Ex parte.
compelled to, yes, my lord, form this ex parte inquiry report only due to non-appearance of the
No,
petitioner.
that you can do ex
Yes.
parte. But ex parte also you have to follow the mandate of Rule 9. You have to call shall, and the word used is shall.
Yes.
You have to call witnesses, examine them, give an opportunity for cross-examination.
But-
Of course, he's
yes.
not there. Documents has to be verified. List of
yes.
witnesses should be given.
If the petitioner himself doesn't appear, my lord, in the first instance, how can the inquiry officer, my lord, proceed to the next stages, my lord? That is one issue that, my lord, needs to be dealt with. And that considering the fact that there is a written submissions of so many officers and witnesses in the preliminary inquiry itself, it cannot be said that the inquiry was, my lord, based on no evidence. Because this was then followed by the first show cause, the first preliminary inquiry. So that contention that it is based on no evidence, my lord, my humble submission that it cannot be, my lord, entertained.
Okay.
Then,
Non-application of mine.
yes, my lord. The other point is, my lord, there is a judgment. Which says that if the inquiry report is accepted in toto, my lord, the disciplinary authority need not, my lord, furnish reasons of penalty, my lord. Unless they have only accepted part of the report, then, my lord, they are supposed to. But here the report was accepted, my lord, in toto. So no need for, my lord, independent reasons of accepting.
Wait, 1 second. I'll just see the impugn order. Okay. Yes. State Bank of India.
Yes, my lord. There, in that case, my lord, they have discussed the case of, my lord, Bolaram Bordole, my lord, which was one of the first authorities which has said that disciplinary authorities, my lord, need not supply independent reasons before, and they can just simply accept the inquiry report and proceed with penalty.
But they have to apply their mind. There's somewhere. What does the Rule 9 say? The what? The duty of the disciplinary authority?
Rule 9, my lord,
Doesn't say.
only says that, my lord, opinion of the APSC may be taken, my lord.
That was taken.
Yes.
Consultation was done.
Yes.
May I clarify your
Yes.
on this point also? That was probably not my case. That reason.
He had not argued also that.
That is not my case. It is a subtle position of law. No reason is to be is required to be given by the disciplinary authority while imposing punishment. My case is that disciplinary authority has not applied his independent mind, because I have shown from the minutes of the meeting that it is as per the direction of the additional chief secretary, your lordship, that this he should be removed from dismissed from service. That decision has been taken, your lordship. Additional chief secretary was not the disciplinary authority. Disciplinary authority was the secretary, and he will have to apply his independent mind to the inquiry report and pass an
No, this impugn order was passed in the name of the governor. Additional chief secretary is the signatory.
lordship. Your lordship will kindly see this order is by the Additional Chief Secretary of Assam, Your Lordship. His name is Seventeen Abbasi. Now, Your Lordship, if in the affidavit, Your Lordship will find they have annexed that minutes, Your Lordship. Also, page 111, Your Lordship.
Yes.
Thorough discussion with the members directed as per rule so and so, the government servants shall not be imposed with major penalty of dismissal. That after discussion with the other members, which include inquiry officer, Your Lordship. That is way, Your Lordship, this is not his independent mind has been applied. Your Lordship. That is my case, not on the reason, Your Lordship.
So that is why I've said that there has to be some application of mind.
Yes,
Now,
application,
where is it?
independent application of mind, Your Lordship.
Where is it? In the rules or in the
No, it
judgments?
is not there in the rules. Rule says that disciplinary authority will pass the order based on inquiry officer's report, taking into account my reply to the inquiry report, Your Lordship. Now that is, and for that, Your Lordship, disciplinary authority is not required to show any reason, Your Lordship. That is what my friend, learned friend is submitting, Your Lordship. Absolutely correct position of law. But my case is not that. My case is that he has not independently applied his mind. He has discussion with the members in which the inquiry officer himself is present. Inquiry officer is required to be unbiased man, Your Lordship. How he can participate in a proceeding, Your Lordship, in a meeting where what the action will be taken by that way, Your Lordship, inquiry officer become biased and the inquiry report got vitiated, Your Lordship. That is my case, Your Lordship.
Achha, yes, Mr. Ibo Thakur.
And
Which paragraph from this judgment? State Bank?
State Bank, my lord, 3.1 paragraph.
3.1.
Yes, 13.1, sorry.
13.1.
13.1. Note, my
Okay.
lord, details.
Then?
Yes. And then, my lord, my final argument is that if my lord thinks there are grounds to my lord interfere, then my lord, it has to be reverted back to the inquiry officer as my lord, as per principles laid down by Honorable Apex Court. Instead of reinstatement, my lord, the usual course is remand. There have been exceptional cases, my lord, where reinstatement is allowed, my lord, no doubt. But the ordinary rule, my lord, especially if there is a procedural component, if it is missing.
But it is always open to you, even if somebody is reinstated, you can always give memo of charges, suspend him, give him. Under the rule, you have to do it.
But yes, my lord. But
remand?
the law says that the usual rule is instead of reinstatement, it has to be remanded, my lord.
Where is that?
Para 6.1. Yes. Para 6.1, if I may read. At this stage, a recent decision of this court, meaning my lord Supreme Court, in the case of Rajit Singh Supra, in which this court had considered its earlier decision, in the case of A. Masila Mani, is required to be referred to in paragraph 15. It is observed and held as under. It appears from the order passed by the tribunal that the tribunal also observed that the inquiry proceedings were against principle of natural justice, in as much as documents mentioned in the charge sheet were not at all supplied to the delinquent officer. As per settled proposition of law, in a case where it is found that inquiry is not conducted properly or same is in violation of principles of natural justice, in that case, the court cannot reinstate the employee as such, and the matter is to be remanded to the inquiry officer / disciplinary authority to proceed further with the inquiry from the stage of violation of principles of natural justice is noticed and the inquiry has to be proceeded further after furnishing the necessary documents mentioned in the charge sheet, which are alleged to not have been given to the delinquent officer in the
But
instance.
here, of course, documents were not given to him.
Whether-
Here,
Yes.
in this case, in the present case, what had happened is he was asked to submit a reply within 7 days. He did not. He, in fact, submitted a reply on merits. And then lastly, in the last paragraph, he writes that I was not permitted.
Yes.
So this instant case is different. And then he had finally gone and challenged the inquiry report, which was based on report of the executive engineer only. Other procedures were not followed.
My lord, may
Yes,
see-
it's different.
My-
But here, see, here there is a stage
Yes.
from where it can be again restarted.
Yes, my lord.
That give him documents and you
Yes.
restart. But here is a case where inquiry report is stated to be bad, right? And then in that case, report will go.
Then it will, my lord, start again from inquiry stage, my lord. If the inquiry is set aside, then my lord, inquiry stage it will go. And my lord may see the succeeding paragraphs. The judgment says, in as a general principle, in any kind of procedural violation, not just my lord, non-supply of documents, other procedural violations also, usual course is, my lord, it is remanded, my lord. There is one, my lord, recent Supreme Court case, my lord, where that was not allowed, even though the Honorable Supreme Court had accepted. There, my lord, the ground was that because some other delinquents who were co-accused were let go of by the disciplinary authority only on that aspect. Sometimes in exceptional situations.
The next paragraph you wanted to show?
16, my lord.
6.2.
In 6.1, my lord.
Or 16 paragraph.
Yes,
quoted.
16. The quoted paragraph. It is a settled legal proposition that once the court sets aside an order of punishment on the ground that the inquiry was not properly conducted, the court cannot reinstate the employee. It must remit the case concerned to the disciplinary authority for it to conduct the inquiry from the point that it stood vitiated and conclude the same, my lord. So whatever point it was vitiated, my lord, the usual course would be to remit the matter at that stage, my lord.
Achha. Yes. Okay, these are your arguments. Yes, any
Lordship,
reply?
Not much, Your Lordship. Since Your Lordship, first point on that reasoning, Your Lordship, I have already submitted before this honorable court. Secondly, Your Lordship, so far as the preliminary inquiry relied on by this, by my friend is concerned, Your Lordship, that
Yes.
cannot be relied on. That is not an inquiry under Rule 9, Your Lordship.
It is only to proceed with
Yes,
the.
Your Lordship, that's a preliminary inquiry. I am, the disciplinary authority is not concerned with that particular inquiry. It is the inquiry conducted by the inquiry officer appointed under Rule 9. That inquiry will have to be taken into consideration. And so far as the last argument of my friend is concerned, Your Lordship, that so far as the demand is concerned, Your Lordship, and reinstatement is concerned, Your Lordship. Now, Your Lordship, there are two things here, Your Lordship. It is a fact that what he has submitted, Your Lordship, that it will have to go back to the authorities, and ultimately authority is always at liberty to proceed against me, since it's this is the allegation of misappropriation. But the point is here in this particular case that I am not under suspension when this particular order by the disciplinary authority was passed. I was in service. Because, Your Lordship,
You were never placed in
no,
suspension.
I was placed in suspension, but subsequently by the order of the Honorable Court, I was reinstated. Your Lordship. And during all the period of time, till the order of dismissal, Your Lordship, I was in service. Now, once that order goes, Your Lordship, I automatically got reinstated in service. And they can always proceed with the inquiry, etc. That is for them to take a call, Your Lordship. Otherwise, Your Lordship, it is not that I cannot be reinstated, because it will be automatic. The moment dismissal order goes, Your Lordship, I will get back to that particular position where from last position, Your Lordship, from where I have been dismissed, Your Lordship.
No, even in that case, if this order goes, you will be, of course, back to your service
Lordship.
by implication.
Lordship, by implication.
But the show cause will continue if I give it from that stage.
Yes, that is for Your Lordship to decide. I will not have anything on it. If Your Lordship finds that this is a case, Your Lordship, where this is should be go back to the authorities, and from the stage where from it got vitiated, it should start again. That's for Your Lordships to take a call on. But this inquiry report and the the order of the disciplinary authority based on this inquiry report is back, Your Lordship, in my humble service.
Okay. Okay, I'll just write your submissions now and then final decision. Yes.
Just one issue, madam.
Hmm.
Normally, it's a settled law, my lord. There are two inquiries, preliminary and regular. Regular, preliminary should have not any connection to regular. That is settled, my lords. That is Kavita K. Jhala's case. But in this case specifically, my lord will find, my learned friend had pointed out, he was called to show cause, he was asked to appear before the in that preliminary inquiry. So this case stands on a different footing, a bit different footing. Normally, and when a preliminary inquiry is held, the delinquent has no knowledge. And that material cannot be used in a regular inquiry. But in this case, my lord, he was asked to appear.
But then it will make no difference.
No difference, but that is a thin line. That is the some microscopic observation. My lord. It's not
Yes.
simplicity of
No, that
argument.
will be like enlarging the scope. It's
My lord.
okay, even if it's call, not call, doesn't
Yes,
matter. Okay. On the other hand, I've already dictated the first part. Huh? On the other hand, Mr. I. Bautakur, Learned Counsel for the PhD department, submits by filing. The PhD department has submitted a written argument, and by relying on the said written argument has argued that the contention raised by the Learned Counsel for the petitioner, that charges are vague and not definite. He states that the same was not in the pleadings of the, this is also a point that he has taken, your charges are not in the pleadings. But that's a law point, so I've said that not required, is not in the pleadings of the instant case. Further, he submitted that the petitioner understood the charges and had filed his detailed written reply after receiving the show cause notice, which shows that the petitioner is not prejudiced by any stretch. To substantiate his argument, he has placed a judgment of BICO, judgment of BIECCO, Lorry, LOWRIE, Limited in another versus State of West Bengal in another. It is on this aspect, right? Another. Reported in 2009-10 SCC 32, by which the Honorable Supreme Court has held that, no, this is supply of materials, right?
For both, my lord, for
Yes.
specificity of charges
In
and
both.
non-supply of documents.
Which was the first paragraph?
First paragraph, my lord.
33 is for that. Yes, 30.
30
Okay.
for charges and
By
32
which
for
it-
documents.
It was held. That the explanation furnished by the respondent, by which it was clearly, by which the respondent had clearly denied all the charges, shows that the delinquent has understood the charges laid down in the show cause notice. The Learned Counsel further submits that the petitioner was given asked in the show cause notice that if he wants to inspect any documents, he may write to the undersigned, that is the Secretary to the Government of Assam, PhD department, within 7 days of the receipt of the show cause notice, but the petitioner gave his reply on 1/8/2019 on the merit of the case, and therein he had stated that he was not given an opportunity to inspect the documents. However, the petitioner had never communicated that what documents he wanted to inspect, and in absence of the same, the contention of the petitioner that he had asked for inspection of the documents and was denied is incorrect. The learned counsel further argued that the contention raised by the petitioner's counsel that there were no witnesses examined during the inquiry. He states that in the preliminary inquiry conducted before the issuance of the show cause notice, witnesses were examined, as can be seen from the preliminary inquiry report, and the petitioner was also called for to answer to his charges. He further submits that petitioner's appearance was fixed on several dates, but he failed to appear on all the occasions. The learned counsel further submits that the disciplinary authority is not required to. Acha, barobar. Eto judgment to nidlo no? Acha, anyways, completed. Disciplinary authority is not required to give findings while give his own findings and reasons while accepting the findings of the inquiry officer, and that in the instant case, it can be seen from the impugn order that the disciplinary authority had accepted the findings reached by the inquiry officer. The learned counsel for the PHA department further argued on the point that even if the court interferes with the impugn order, the reinstatement of the petitioner should not be allowed in view of the law laid down by the Honorable Supreme Court in a number of judgments. Full stop. He has placed one such judgment rendered by the Honorable Supreme Court in the Inspector of Panchayats and District Collector, Salem versus S. Arichandran and others in Civil Appeal number 6776 of 2022, by which it was held after referring to other judgments of the Honorable Supreme Court that in case the punishment is found to be wrong on the grounds of violation of natural justice, the case may be remanded back from the stage where there is violation of natural justice, and that the delinquent employee may not be reinstated. Eta heri korason. Is a heri kolu non-supply of Hey, recording regions যে করলো যে recording regions it or submission he has he has relied on a judgment passed by the Honorable Supreme Court in State Bank of India and others versus Ramadhar SAO, reported in 2025 INSC 1010, by which the apex court had held that disciplinary authority is not required to record regions in detail if report of the inquiry officer is accepted. So these are your submissions. Rest I will dictate it in the chamber.
One judgment, Your Lordship, that is, Your Lordship, from the Public Health Engineering Department itself, Your Lordship, that may help Your Lordship. That is the WPC 2211 of 2024. He was an executive engineer, similar allegation of misappropriation. And the Honorable Court was pleased to, my friend was there, Your Lordship, pleased to set aside. Your Lordship may kindly see para 16, Your Lordship. What the
Set aside the impugn order and
reinstate the petitioner with immediate effect, giving them liberty to initiate the proceeding from the point where it was initiated. Your Lordship.
okay. Okay, I'll take this.
My lord, another citation, Lordship, I'll trouble, my lords. The Gunashekhan, P. Gunashekhan's case, my lords.
Acha, give me the citation.
I'll give you citations, my lords. And that particular case is relied upon, my lord. We have started again and he's retired also in the meantime.
Oh, you have started disciplinary proceeding.
Yes, my lords.
That was granted, liberty
Yes,
was
my lord.
granted.
Now he has come with a writ petition criminal.
Acha.
That we are relying on some FIR.
Acha, you give that
That's it.
citation,
Fine, I'll
I'll
give
record it. Okay.
Deeply observed.
Petition is disposed of.
Okay.
You'll get the order by tomorrow, day after. If not tomorrow, then Monday. I have other judgments to do. Yes, okay. Etu lalo. Mo chamber di dibo. Otherwise dispose of did na. Ekhini tumi hearing di dilo. Dorothy. Or whatever. Oh. Yes, etu ki. Yes, 48. Yes, Purcaster.
Yes, last question, Your Lordship was asked me to place them.
What about the other side?
That the secondary reason.
Wait, affidavits filed? No, affidavits not filed. They'll come up with the prayer. Yes, who appears? Elementary, secondary,
NCT
what?
is there, NCT is there.
Oh, NCT. NCT who appears? You're there? Acha. So secondary education also requires, he is for respond number 4. Yes, Mr. Dhar, you are for secondary education. Secondary, Dimpi, Mushari and all were there.
I can find out from.
Acha, affidavits required to be filed by NCT, I think.
Not
What?
required.
Accordance with the NCT, my lord, that is, Your Lordship may found it page 30, my lord.
So then secondary will be required.
Yes, my lord. Because, my lord, Your Lordship may found it, my lord, one chokos is page 42, my lord.
32.
42.
42. Yes.
Hence, you are called upon to explain the following: how you attend the regular classes for B.Ed course without hampering your teaching duties at Shivastan ME school, whether your regular attendance and duties at your appointed school are affected in any manner during the period of the B.Ed course.
Of course, if he goes and attends the courses, then to his work will be affected.
So,
Yes, Mr. Reem. Yes.
Here, my lord,
Kaushik?
basically, the petitioner has challenged the so-called notice. If your lordship finds the permission which was granted to him, that permission has a condition. So, in this so-called notice, an explanation has been.
So he sought for permission to continue.
Yes, and he was granted.
Before admission.
My lord?
Before admission.
For admission. And he was granted a permission with a condition that it should not hamper his normal duties as a science teacher. Now, this so-called notice, my lord, if your lordship file, an explanation has been called for.
Yes.
From him.
This was during his During his course or what? This show cause notice while he was undergoing the course
No, after.
or finishing?
After finish.
Huh.
He has been asked to explain, Lordship find from the bottom second paragraph. Two questions. How did you attend regular class for B.Ed course without hampering your teaching duties at so-and-so ME school? This is one of the condition while he was granted a permission. That
Condition that he should do his classes.
he should continue with the course without hampering his normal duties as a teacher. Second is whether your regular attendance and duties at your appointed school were affected in any manner during the period of B.Ed course. And why it is, my lord, if a lordship comes to the B.Ed certificate, my lord. Page 28.
28.
Yes, ma'am.
Yes. Huh. Yes.
So certificate of here lordship will find he or she eligible for award of Bachelor of Education part-time.
This is a certificate.
Yes,
Huh.
certificate. As a regular examinee since 2016 to 2019. In June, as a regular.
Reading or telling on your own? What?
Sorry, madam.
No, I'm not getting it. 27.
Page 28.
28, yes. This is a certificate.
Certificate.
Niruppal Goswami.
Yes.
Mother's name so-and-so, roll number so-and-so. Is she eligible?
For
She, award of
Bachelor of Education B.Ed time part-time.
Part-time.
As a regular examinee since 2016 to 19. In June 2019, as a regular student, my lord will find regular student.
This is part-time. Maybe at night he appeared. He attended.
Sir, my lord, your lordship will find this is a institute at Swami Vivekananda University, Madhya Pradesh.
So maybe online classes?
No, B.Ed there cannot be, my lord. B.Ed is a regular course, my lord.
No, my lord. There, sir, my lord, audio modes are there. And it's a 3 years part-time.
And the permission, my lord, will kindly see page 33. Subject to the condition that normal duties incumbent of science teacher should not be hampered.
Yes.
What about his attendance in the school?
So that's what, my lord, we
It
have
was
called.
checked.
No, that is why the so-called notice has been issued to explain, because that has to be checked in the disciplinary proceeding if the authority proceeds with. So he basically has challenged the so-called notice, my lord. So unless, my lord, there is a power under the authority to proceed.
Judgment saying that show cause notice.
Yes, my lord, there are many judgments.
Yes.
There are many judgments that where if there is a initiation of a disciplinary proceeding, since it is an administrative act, and if the statute provides that power, so normally the court should not interfere.
No, it has decided any of your rights, so this will not amenable for challenge.
And in fact, my lord, the order of this honorable court which he is relying upon, my lord, there are judgments of this honorable court on this point, where, my lord, this honorable court has held that in terms of the conduct rules, though the degree cannot be said to be invalid, but it perhaps may be a misconduct if without permission one pursues a degree. And this honorable court also, taking note of the earlier judgment, my lord, would kindly find page 34, is relying on this judgment of this court, coordinate bench of this honorable court.
Yes.
Relying on the earlier judgment, this honorable court comes, my lord, comes to page 41. In that case also, the so-called notice was challenged. Page
Directing them
41.
to consider a claim only as well as other who are eligible for consideration of in-charge principal.
And take necessary
This
steps.
is consideration for
Yes.
the post of in-charge principal.
Yeah, last paragraph, my lord, points. This court, however, makes it clear that it is not interfering with the disciplinary proceeding initiated against the petitioner. And rightly, my lord, this is the
It's
proposition.
a settled position. You
Settled
can challenge show cause.
My lord, may I permitted to submit my I will give some judgments. So that is okay.
But then I think I've also seen the judgment of Justice Michael saying that show cause notice are not amenable to challenge.
No, it is not like that. I'll clarify.
Show me the judgments. Those judgments will be again in different facts.
No, 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 my lord. First, I take your lordship,
Show
my lord,
cause only, it's,
before, giving
it's
the-
telling you to show the cause why such and such
Yes,
thing.
before going to that step, I am giving, my lord, I take your lordship to seniority list, my lord.
Merit wise, you might have a good decision, a good
Page 25.
case, page 29,
Yes, page 25.
25.
Yes. In page 25, column number 12 and 16.
Column number,
12 and 16.
yes.
But these two columns have been, my lord, interfered by this honorable court. In this judgment, my lord, I just have given page 416 and 2000 of 2000.
No, column 12 is Gauhati University BSc
No, no, no.
Krishna.
This, it was, my lord, whether you have 13 years lordship will find if education qualification acquired in service, please state whether previous permission or NOC appointing authority was obtained from the appointing authority was obtained or not.
You had the permission,
Yes, I had.
but subject to a condition.
Subject to a condition, and I have rendered my services without, and I have completed my course without hampering my duties. As a result, I have been paid also. That is not in dispute. And this honorable court, my lord, these two columns asking for NOC have been interfered with. This in the first judgment, I have given, my lord, Dayananda Bhuya. In this column, last page, page number 6, you should find. It was this was a circular. This guideline was format was circulated for a circular, my lord, and you will find it is interfered with.
Okay, but
It is not a requirement as on today. This is not a requirement.
Not a requirement.
The stock was
Accepted.
Yes, and my lord, the another judgment I have given.
So what you mean to say, without permission, one can pursue the courses?
Yes. Without permission, one can pursue this another judgment. My lord, this honorable court in the similar case I have given.
Wait, I'll see this judgment.
Yes, Jayanto Niyog, my lord. Just now given.
Wait, I'm seeing the earlier one.
Earlier, Dayananda Bhuya, my lord.
Here, permission was obtained, NOC was not given.
They both the same thing, my lord.
But then see, there is a difference, it seems. Notwithstanding absence of NOC, though permission was obtained.
Yes.
And since clause 12 and 16 stand an embargo in selection of the petitioner to the principle, the same are interfered with, being the Rule 13 cannot stand in the way of giving effect of the constitutional provisions, 15(1)(j). Coordinate bench.
And the next judgment, you know, will find.
No, there is a difference made between no objection and the permission required.
No difference, my lord.
No, but no, it's made in, I'm not telling, this husband says.
No objection means, my lord, the authority has no objection in allowing me to pursue the course. And permission means, my lord, to allow me to pursue the course.
Same thing, but
Amounts to same thing.
But then, while interfering with these clauses 12 and 16, that is given in this judgment. See, because in that case, permission was acquired, was obtained.
Yes.
But no NOC as such was not there. That document was not there.
Permission and NOC the same thing, my lord.
Whatever it is, but then
the same coin.
But then it is not said that permission would not be required.
And here in this case, my lord,
in this chart NOC, that provision may not be there.
Impune Shokos notice what they have asked, my lord, the two questions. Two questions: how did you attend regular class for B.Ed course without hampering your teaching? This is a part-time course. I have only attended for examination, my lord. It was not for
That is in the merit of the case, but whether show cause notice can be challenged.
Yes, show cause notice challenged in this set of judgments, my lord. Show cause notice has been challenged.
Where is that? Show me.
My lord,
this joint link is for what?
Yes, this is also for NOC, my lord. Joint link for case is filed, my lord. And this honorable court, my lord, at page 23, paragraph 47. has made some guideline, my lord. Page 25, my lord. Determination made in Moshomi Shohoria cannot be termed as any direction to the authorities in education department to initiate departmental proceeding against all the teachers who prosecuted studies through distance mode from the scheduled institutions incorporated in Schedule 3 of the rules such and such. And they have given me permission to pursue the course.
They have given you
Yes,
the
therefore,
permission.
yes, therefore, why this show cause, my lord? First time you allow to pursue, therefore, after pursuing, my lord, you impose the show cause notice.
Hey, you file your reply, they will
I
make
have
it
given
drop
the
it.
reply, everything given, my lord. They have done nothing as on take.
My lord will dispose the direction with a direction
That
to.
they will finish.
Yes, my lord.
They will
We'll proceed
reply.
with the.
They will consider your reply and reach to a logical end.
Yes.
This is one part, my lord. But why why I have not been allowed to, my lord, hold the charge, my lord? I have not been given the charge also for the principal of the school. This honorable court in a similar, my lord, direction, while page 41, my lord.
That means you are placed under suspension.
Not suspension. I am serving in the school, my lord, but I am not allowed to hold the financial charge of the principal.
You are otherwise in charge principal.
I am academic. Chair.
You are simply not given financial power.
Yes.
But you are in charge principal now.
Academic in charge. Academic in charge.
Academic in charge only is required. Why do you want to deal with finances? Let others do it. You teach.
Only
You teach students.
Inspector of schools is my lord.
Everyone wants this financial power.
That's something very lucrative, actually.
There has to be something more than what meets the eye. Acha, whatever it is, I'll dispose it of. Otherwise, you have some decision. So-cause notices cannot be challenged.
That I have given, my lord. That my decision is made in my favor.
No, no. This is what the proceeding should not start.
Yes.
What? Where? Wait, I've seen this.
Page
In fact, that is.
Moshumi Shohoria cannot be termed as any direction.
Yes, that is,
Yes.
my lord, that is pursuant to a challenge. What happened, my lord, there was a general circular issued by the director to all the inspector of schools in terms of Mosumi Shohoria's order that whoever has pursued degrees without permission should be inquired into. So in that context, this honorable court has said that there is no direction in Mosumi Shohoria. Mosumi Shohoria, in the Mosumi Shohoria judgment, this honorable court has said that Rule 13 of the Conduct Rules of 1965, if it is seen to be violated, it can at best a misconduct. But however, that would not invalidate the degree which is otherwise valid.
Yes, yes.
That
Rule
is what the
13 of
proposition.
which rule?
Rule 13 of the
1965.
Assam Civil Service Conduct Rules 1965.
Conduct rules,
Conduct rules.
1965.
It is quoted in this, my lord, judgment. I have annexed.
Okay, okay. Heard Mr. B. Purkaster, learned counsel for the petitioner, and Mr. B. Kaushik, learned standing counsel for
Secondary education.
secondary education, and Mr. I. Alam, learned counsel for respond number 5. That is NCT 4. That is National Council for Teachers Education. By this application, filed under Article 226 of the Constitution of India, the petitioner has prayed for setting aside the show cause notice issued on 9/5/2025 by the Inspector of Schools, Nagaon, by which the petitioner was asked to show cause as to why. Where is the show cause?
Page 42.
Show cause as to why asked to show cause in respect of two queries.
Two queries.
One, how did he, how did he attend regular classes for B.Ed course without hampering his teaching duties in the school? 2, whether the petitioner had regular attendance and whether he had regularly attended to his duties in the said school? Full stop. The case of the petitioner is that he is the senior most assistant teacher serving in Sibasthan High School, Nagaon. Sibasthan, High School, Nagaon. The petitioner has joined in the said school in the year 1992 as a science graduate teacher. And during his or her, during his service tenure, the petitioner decided to pursue his B.Ed degree on part-time basis and for pursuing the said degree, he had applied. Where is that conditional permission?
Page 33, my lord.
He has applied. He has applied to the District Elementary Education Officer, Nagaon, for the necessary permission.
This is granted by the director, my lord, director elementary. While he was serving in the ME school, my lord, it is granted and.
He has applied before the director, right?
Yes.
He has applied before DEEO, no, Director School as Elementary Education, Assam. And the director,
After that, his school is amalgamated with the present school. That is the.
And the director of elementary education, by the order dated 15th of December 2017, had accorded approval, that is, accorded permission to the petitioner to pursue his B.Ed course, but it was made subjected to the condition that while pursuing the said course, the petitioner should not petitioner should continue with his normal duties as the teacher of the said school, and that his normal duties should not get hampered. What thereafter some amalgamation you
Yes,
said?
on 20th January 2018, my lord.
This permission was before that?
Before that.
Before, while he was in the ME school.
In the elementary section. Now it is under secondary section through this amalgamation.
Thereafter, it is stated that the school of the petitioner, that is
Shibostan ME school.
Sibasthan, it was high school later.
Now it has become
No,
high school.
it be stated that initially the petitioner was appointed in the Shibasthan ME school. When he had applied, Shibasthan ME school, and when he was working in the said ME school, he applied for the said permission. And after the said permission was granted, the said school was amalgamated with the secondary,
Shibostan High School.
Was amalgamated with the Shibasthan High School, Nagaon, wide order dated 21/2018. And the service of the petitioner was merged with the secondary education department. And he was given past service benefit. The petitioner has, in pursuance to the permission given, pursued his B.Ed course before the Madhya Pradesh, before Swami Vivekananda University, Sagar, Madhya Pradesh, India. And a certificate was granted to him on 18/2/2021, wherein it was shown that the petitioner is eligible for award of Bachelor of Education, within bracket B.Ed, comma, part-time. Full stop. It was also stipulated in the certificate that the petitioner was a regular examinee from 2016 to 2019. And in June 2019, he was a regular student. However, on 9/5/2025, a show cause notice was issued to the petitioner by the Inspector of Schools, NDC Nagaon, by which it was intimated to the petitioner to show cause on 2 queries as stated above. It was also stated therein that as per Rule 13 of the Assam Civil Service Conduct Rules 1965, no government servant shall join or attend any educational institutions or appear at an examination of a recognized board or university while continuing in his service without obtaining previous permission from the appointing authority. It was further stated that although permission was granted to the petitioner to continue his B.Ed course, but the same had a rider, that is, his normal duties should not be hampered. But it was seen by the authorities concerned, as stated in the said show cause notice, that the petitioner had pursued the course as a regular student, which raises concerns about his discharge of his duties, about discharge of his duties in his school. As such, he was given 7 days time to reply to the show cause notice to show that his pursuing the B.Ed course had not hampered his duties in the school he was working as a teacher.
The petitioner has submitted the reply in response to this one.
The learned counsel for the petitioner submits that in pursuance to that show cause notice, the petitioner has submitted his reply before the authorities concerned.
And while, my lord, he has stated, my lord, he has not taken any leave from the schools, my lord, and he has done this course during the holidays, my lord. His exam was in the holidays, my lord.
That would be a part of his reply, if it is there.
He
My
further,
submissions also, my lord.
further submitted that petitioner had never taken leave from his school and that he attended his school regularly, as the attendance register would show, and that he had pursued his B.Ed course in the off time. However, Mr. B. Kaushik, learned standing counsel for elementary education, secondary education, submits that the petitioner being shown as a regular student of the B.Ed course in his certificate issued by the university, issued by the Swami Vivekananda University. কি বুলি ক'লো প্ৰথমখিনি নহয় তাৰ অকণমান আগত কেইটামান ষ্টেটমেণ্ট কেইটামান ৱৰ্ডছৰ আগত কি makes it clear that the same had hampered in his normal duties as a teacher in the school. Be that as it may, it is also seen in a number of judgments passed by this court as well as by the Supreme Court that show cause notices does not determine any rights of the petitioner, and as such, the same is not amenable to a challenge before the writ court under Article 226 of the Constitution of India. The petitioner was simply issued a notice to show cause as to the fact that he being shown as a regular, not examinee, what did you say? As a regular student as a regular examinee from 2016 to 2019 and a regular student in June 2019. Would normally conclude with the fact that he did not attend to his classes in the school during that said period. But at the same time, it is also reflected in the certificate that he was awarded the Bachelor of Education degree on his part-time,
As part-time course, my lord,
as a part-time course,
which is recognized by the NCT.
as a part-time course or otherwise, as a part-time course or otherwise.
Which is a recognized course by the NCT.
No, otherwise. It is as such, no definite findings has been recorded by any authority that he had hampered, he had not done his duties in the school. It is yet to be determined, and only a show cause notice was issued to him, to which the petitioner states that he has filed a reply. In view of the fact that no decision has been reached yet, and there is every possibility that the authorities concerned might drop the charges leveled against him at any point of time, this court directs the petitioner to participate in the said inquiry process.
They have not issued any, my lord, inquiry till today, my lord, for last 1 year.
It's okay, I'll tell them.
Yes.
Inquiry process, full stop. It is also directed that the authorities concerned would not keep the petitioner hanging with a show cause notice and a reply, and would proceed with the inquiry or disciplinary proceeding. A disciplinary proceeding has
It's
started.
not yet.
Not yet. Preliminary inquiry done.
This is a preliminary inquiry show cause notice. It's not under rule
Not
9.
inquiry even, my lord, the show cause notice.
It's not under the Assam disciplinary appeal rules.
No, Assam 9 will provide for a show
They were
cause.
started once it
Because
is-
this is not a show cause under rule 9.
This is not
So,
mentioned.
yes, and an it is as an explanation has been called, perhaps.
কি করলো person? And a reply. They should proceed with the inquiry if they decide upon. Without any delay.
Conclude the same, my lord, within a period of 1 month.
No,
As on
they
today,
may
my
not
lord, the authorities have not even contemplated
decided.
of.
Huh.
That's
So what?
in
That
the- in
it
the-
is like always you continue and
in the
finish it.
event, my lord,
You
they
once
decide-
done disciplinary proceeding to be initiated.
Uh-huh.
No, no,
So
no,
no,
my lord. I'm not in the event they decide to drop, my lord, they may drop by passing a speaking order, my lord. That
no,
was-
I said that they would drop also.
Yes.
But with this observation, petition is disposed of.
And my claim for, my lord, headmaster,
Oh, charge.
it is to be considered by the DSC as well, my lord. And the direction should be
I said
given.
you were not suspended.
Not
You were not
suspended,
demoted.
not
But
suspended.
financial power is taken.
Yeah.
He's still
It's
enjoying.
okay.
No, no, power is not taken, it is not given.
Oh, it is not given.
Not given, it is not taken, it is not given, my lord. And my lord.
You want all the reliefs together. No, that is okay. You are in charge principal. Be happy with that.
Grateful, my lord.
My lord, that way, in the event of, my lord, the closing of the DP, my lord, it may be considered. Otherwise, my lord,
That you again come. You again come.
Hmm.
You will definitely come, I know. Yes. Wait, he had challenged the show cause notice, no? Oh, let it remain. Yes. Yes, Mr. Chetri, what is the matter?
My lord, this is a matter, my lord, which has come, my lord, before your lordship for admission.
Huh.
Matter of my lord, the wife entitled.
You are there for the Indi matter?
For the respondent number 3, may
What?
may I please kindly allow me 4 weeks time to file affidavit.
I cannot deny also.
Your lordship cannot deny, not
I
4
cannot
weeks.
Sometimes
Yes,
I
but,
deny if it is too long. Yes.
That may be fixed, my lord, with all respect.
Yes, yes.
Because this is a matter
Huh.
pertains to.
Mrs. Roy was there for respondent number 1 and 2.
I'm for the respondent number
Huh.
1 and 2. We are filing our affidavit.
Acha, you are representing 3.
You representing.
Acha, acha. So 3, actually last time notice was not served.
My lord, may I clarify my?
We got notice on 19/5 today.
The wife is
Hmm.
entitled for GPF of her deceased husband as a subscriber of a central government
Hmm.
employee. Wife is the nominee of the deceased husband, a record reveals. Accordingly, the husband dies, leaving behind wife, family, comes under Succession Act. Wife, by writ petition, Annexure 7, was given entitlement, everything of the beneficiary, benefit of GPF, everything. Annexure 7. Subsequently, same officer, that is respondent number 2 of the Doordarshan Kendra, which comes under central. Now, respondent number 2, all of a sudden, gives Annexure 8, that is been stayed by this honorable court. What does Annexure say? All of a sudden, the deceased husband, sister comes into a picture, claiming that before that of her brother made nomination to her.
The gratuity should be paid to her.
GPF.
GPF.
Pension and gratuity, all that benefit is given by the wife. Now, all of a sudden, this comes.
The sister comes.
Sister comes in the picture. That sister is respondent number 3.
Acha.
And by the order dated 24/4/26, we have been implemented her as a party respondent number 3 and issuing notice, and she have appeared and she filed wakalatnama.
Whether sister is entitled for any.
I don't think so.
It's not provided under the rule.
Law, man.
Let's see.
Let her give the affidavit. Affidavit within a 15 days from now. She asked for 4 weeks. Let her give her 2 weeks. Before holiday, my lord.
So 19th of June.
19th will be the best.
19th of June.
Okay.
Miss, heard Mr. K.D. Chetri, learned counsel for the petitioner, and Miss S.S. Roy Jr., you?
Are they appearing on behalf of assistant?
Miss R. Dave,
Affidavit.
appearing on learned counsel, appearing on behalf of S.S. Roy, learned counsel for respond number 1 and 2. And Miss,
I am appearing on behalf of JP Das.
For respondent number 3.
on behalf of
JP Das.
JP Das. Miss
Susmita Das.
Susmita S. Das, learned counsel, appearing on behalf of Mr. J.P. Das for respondent number 3. Ms. Das submits that she be given an opportunity to file the affidavit in opposition in the instant case and has prayed for some time. Prayer is allowed. List this matter on 19th of June.
Much of great respect. That is the fact.
It's okay.
49 and 50.
For 4950, Mr. D. Bora, N. Bora, Nirenda was here. Niren Bora was here. Okay, call it up after some time, Mr. Hemenda. Niren Bora was there. Yes. 51. Yes. Place the instructions, respondents shall place the instructions on the next date. What happened? Do you have it?
No, Your Lordship, the board of ASTC is defunct now. New board will be constituted after 30th of June.
Oh,
Lordship
it's
may
okay,
kindly-
defunct now, but what about the earlier cases?
Yes.
Who will place the instructions?
Since 21/1/2026 is requiring the instruction. Lordship will come to the order dated 21/1/2026.
21/1/2026, yes. K. Borpujari appears for some order, indicate service. Okay, so his case will be placed before the DPC
Yes.
and meeting to be scheduled in the month of February 26. Then what happened?
Lordship will then,
After that, complete her instructions.
every time they come with a new plea. Lordship.
So ASTC's standing council was supposed to complete her instructions. Your defunct body will not be the answer.
Lordship, the man is retiring in December. They are just dragging the matter, Lordship.
So who will bring the instructions? Who was ordered?
ASTC.
Who is the learned counsel for standing counsel for ASTC? Who
Dr.
is-
A. Chomwa.
So where is he?
Lordship, he is not present. He is unwell.
You are appearing for?
Transport.
Same, ASTC.
Transport department.
Transport department, yes.
Yeah.
So Mr. Chomua has to be here. He might be having some instructions. We'll take it up tomorrow. We'll tell Mr. Chomua to be here. Okay. On the prayer made by the council appearing on behalf of Ms. Dr. A. Chomua, list this matter tomorrow, that is 5th of June.
Obliged.
I have obliged.
May I please, Your Lordship?
Hmm.
Lordship, in this matter, I'm appearing for the department here, my lord.
Hmm.
We have filed our affidavit, my lord, in the main case, my lord,
Hmm.
which is WPG 4861 of 25.
Hmm.
And my lord, there is an IA which was filed subsequently by them, my lord,
Hmm.
which is IA 816 of 26.
Hmm.
In that matter, my lord, we are filing our affidavit tomorrow, my lord, in opposition.
Okay, right. Let
my
them
lord-
file it tomorrow. We'll take it up next week.
My lord, well, they might want to file a reply. So my lord will give 2 weeks, my lord.
2 weeks.
2 weeks.
2 weeks, the last week will be a motion week, I think, so not fair to.
We'll give a date, man, because this is a disciplinary proceeding matter, man. Already under section 26, my lord, of the, I mean, the thing, my lord,
Which
this
rule?
thing of the Assam Discipline and Appeal rules, my lord. The review has been done, man. Regarding
Okay,
the
we will
quantum
go
of,
into that. In the IA, you write Mr. A. Fukon, learned counsel for the GAD,
my lord, yes, my lord. General Administration Department.
General Administration Department,
Standing counsel.
states that he is yet to file the affidavit in opposition. And
In the
has
IA.
prayed for-
IA.
In the IA, I said, and has prayed for some time. Prayer is allowed. List is, prayer is allowed. And then in the writ petition, you write Mr. Fukon submits that he has filed the affidavit in opposition in the main writ petition.
My lord.
But since he has not filed his affidavit in the IA, he prays for a short accommodation. He also submits that he will be filing the said opposition affidavit in opposition tomorrow.
No, yes, ma'am. I'll be filing tomorrow, ma'am.
File it soon,
During the course of
as
the
the same is ready. As such, list this matter on 22nd June.
Well,
22nd of June. Okay? Agree on a date.
22nd June.
22nd. AM doctor. কিমান কলে? 28. Dr. R. Sharma. You are there?
Pisha.
Uh-huh. Oh, okay, good. 2018 matter, no adjournment, yes. Oh, Mr. Ahmed was there, right?
Yes, your lordship.
Acha, I told him to go back because I don't like sitting, make him sit for long. So what happened? He will do or you will do?
Today,
But in 2018 matter, let's hear and dispose it off.
let us
Am-
try, your lordship.
Mr. Ahmed is not required, you are enough.
No, let us
Okay.
try, your lordship then.
And what about other respondents?
No, it's only for company only. I'm
Acha,
there.
acha.
Coal India Limited.
Just let me see the array of respondents. Coal India. Acha, you are there for Coal India.
All the
And Chief
respondents.
Manager Coilery, Margarita.
All
So all the three you are appearing.
Yes, all the respondents.
Yes. Okay.
Filed an affidavit also on behalf of all the three.
Okay, fine. Yes.
My husband was died in, on 29/7/2007. After that, I applied.
29/7/2007.
After that, I approached the respondent authorities for the terminal benefits and and for compensation appointment or monetary compensation in lieu of the compensation appointment. After that, I have received some terminal benefits. I have received gratuity and provident fund, but compensation I do not receive. So for that, my priority.
Compensation is allowed for.
Yes, as per rule.
He died in harness.
Harness on 29.
Compassionate appointment, okay, but compensation.
Not
Exactly.
It is under the terms
compensation.
of.
Yes, and we have a set of rules, and your lordship, if your lordship will
Page
kindly take
27, no.
27, 26 of our affidavit,
Page 27.
27.
Monetary compensation
Monetary
regarding
compensation,
money
the-
is
the
required.
provision is there, but it is not automatic, your lordship.
Yes,
Yes,
of
sir.
course, things has to be seen
Yeah.
before allowing compensation. But she fulfills, he or she? She,
Why?
the wife of the
Wife of
deceased. So you had applied for monetary compensation, right? But you had applied it little late, delayed. No, what I can see from your monetary compensation has been regretted. What is? This is to inform you
For
that a
delays,
monetary
they have said.
has been rejected perhaps on belated ground.
On related ground.
Then what page you wanted me to see? In their affidavit?
Page 27 of our affidavit. So it starts from page 26. That is the extract of the provision. Your lordship.
Acha, let her finish.
Yes.
Yes, 27.
Page 27,
Hmm.
para 9.5,
Hmm.
Roman 2.
Hmm.
In case of death or total permanent disablement due to clause other than mine accident and medical unfitness, order clause 9.4, if the female dependent is below the age of 45 years, she will have the option either to accept the monetary compensation or rupees 3,000 per month or employment. So I have applied for the monetary compensation.
Okay, so monetary compensation of 3,000 per month. It's almost like pension or whatever. 3,000 per month.
Or it is or.
Huh?
Monetary compensation or rupees 3,000.
No, off. Off rupees 3,000 or employment.
At that particular
At
point
that
of time,
particular-
yes. Now,
This is
when-
the what? This is the guidelines or what?
Yes, yes.
This is
The main.
MOA.
Yes.
Hmm.
Passed in 23rd December 2000.
So 2007, he died. And she applied, of course, late. Then because of
As per their record, they said that 6 months delay
6 months delay in applying.
apply.
Anything in the MOA showing that if there is late in submission, then it will be rejected? Nothing of that sort?
Not rejected, Lordship.
This amount of compensation per month will be in addition to the pensionary amount. Whether they are entitled for pension?
No, your lordship.
Oh, acha. Then what have you challenged? The
Lordship,
rejection?
kindly see the page 29 of the affidavit of opposition,
Hmm.
Annexure 2. Second para, Lordship. The matter has been viewed very seriously by CIL headquarters. Henceforth, the dependent employment monetary claims received
Hmm.
after 6 months from the date of the death of the employee will not be entertained and forwarded the proposal for competent approval.
Hmm.
They do not reject it.
So what happened to the approval? Not granted. So the approval was supposed to be granted by Kolkata director.
Yes, Lordship.
Then what happened?
After that, we do not, that notification issued on 8/8/2012. This is not applicable, Lordship. Lordship, petitioner husband died on 2007, so this is not applicable.
What? Annexure 2, page 30?
Yes, Lordship. Annexure 229, page 29, type copy. This notification issued on 8/8/2012, Lordship. So retrospective, it cannot be applied retrospective effect. When the husband was died, Lordship, petitioner husband was died, there was no effective rule there for belated.
It is like compassionate appointment. If you delay in applying for the same, it shows that you were able to survive and all those things you have seen. So here also is a case you have not applied in time for compensation. So that means that you are surviving, you are sustaining. So no compensation. Yes, what do you say, Mr. Reddy?
Yes, Your Lordship. This notification, what my friends showed.
This is what
This
you have
one
put
is
to
a-
challenge, 8/8/2012.
This
Not
one is a,
challenge, only
not yet challenge. This one is a general notification, only, Your Lordship. And here, and this benefit is more like a compassionate relief, Your Lordship. In our company, this benefit are taken care of the provision, Your Lordship, that annexure 1, Your Lordship.
Of your affidavit?
Yes. This one is a extract of the main this provisions. Your Lordship. And so your Lordship can see that this the benefit is more like the compassionate appointment. And
Yes.
Your Lordship, the main thing is our main play is the belated application. And then for this, Your Lordship, the dates are very crucial, Your Lordship. The husband of the petitioner died on
29/7.
29/7/2007, and they applied on 25/2010.
25/2010.
That is 2 years.
3 years almost.
Yes, 2 years.
10 months.
And in between, they received the gratuity and the provident fund, which covers 8 lakhs more, Your Lordship. So the question of the sudden crisis. does
You
not
do one
applicable
thing, you
in this-
consider our case and reject by speaking order.
That can be done, Your Lordship. Otherwise, because at this juncture, now after 20 years, so it will be more difficult. And Your Lordship can, and in their petition also, there is no explanation for delay. They filed the petition in the year of 2018 only, after 10 years of date. So at this stage, Your Lordship, that will be more difficult. And Your Lordship, the judgments are there. They are catering of judgments.
Okay, you consider her case. I'll write those facts. Of course, there is a delay.
There's a delay.
But
Yes,
then,
it's 20 years, Your Lordship.
She is below 45 years.
Yes,
Now-
at that time she was below 40.
At that particular time,
Hmm.
but the anxiety is that they approached the company after 2 years and they filed a petition after 10 years.
So many.
So the delay is unsustainable. So at that particular point, so not say, so the consideration at this belated stage.
I understand, but instead of rejecting him, let her file an appraisal. You have filed a representation in all.
Yes.
Then any reply to that?
I know that.
So whatever,
Application is pending, they have.
No, the annexure D of their petition. So their claim was regretted, your lordship. Regretted means rejected.
rejected, this is a. it's not-
Terminology regretted their right, but it should be rejected, your lordship.
Acha, acha. That, so your representation stands rejected.
Rejected, your lordship. In the year 2013 itself. And they came before this court in the year 2018, after 5 years, your lordship. And there is no explanation in the petition also.
But then the general what she had shown from page 29,
29.
that is of course in 2012. That is after her husband's death.
That
So,
is there. But your lordship, the provisions and the procedure was prevailing long back. Only in the year 2012, what did the company did? They made it more standardized in the written format only. Otherwise, the practice was prevailing long back.
even if consideration order will not do, they will consider and they will reject, like they have rejected
Yes.
on the grounds of
And
delay.
at this stage, your lordship, now it is 20 years, so that's a difficulty. And your lordship, what
What was your
proposition of
instruction?
law? Yes.
At that time, Lordship, 2007, there is no provision for the bill.
That was not a, but
That
it
is a
is
written
at
note.
par with compassionate appointment type. It has to be
But
quick.
page number 29, Lordship,
She might not know, that is also a fact.
they have not rejected, Lordship.
But in the petition itself, there is no any explanation to that effect. The petition is, your lordship can see the petition otherwise.
It's okay.
And this notification we brought only to more to give a formality. Otherwise, the practice was prevailing long back, your lords. And your lordship, the judgments are there. Otherwise, the lordship well aware that the latest one is of 2025. That one also is very clear. Devabrata Tiwari here also.
Oh, Devabrata Tiwari, we know.
Yes,
This is
so
on
very-
compassionate appointment.
Yes, and since we, because we treat this as at par with the compassionate appointment, so the analogy and the rules will be applicable in the case of monetary compensation also. And the pecuniary case will not come because your lordship, they receive a quite substantial amount of 8 lakhs rupees. They receive.
See, ignorance is not, cannot be accounted for, cannot be.
They do not reject it, they mentioned in page 29.
This regretted is
Regretted
wrong.
means, yeah.
Not regretted.
No,
Kindly see page 29, the matter.
29.
29,
29. It's
affidavit
not,
opposition, Lordship.
it is not of her case, it is a general
Oh,
document
this is-
certificate applicable.
Enclose it, Lordship.
Yes.
The matter has been viewed very seriously by CIL headquarters. Henceforth, the dependent employment monetary claims received after 6 months from the date of death of the employee will not be entertained and forward the proposal for competent approval, Lordship. So it may be pending there. So what is the status of that?
That is wrong, your lordship. Your lordship can come to the first paragraph, your lordship. It's a general notification applicable to all, not her case.
No, this is general.
General is not
So
her
whether
case.
it can be granted after 6 months, that requires some approval from the Kolkata.
But this
And the
notification,
approval was
Lordship,
given.
cannot be applicable, Lordship. On judgment, I have seen.
Hmm.
Retrospectively, it cannot be applied, Lordship.
That is the formal part only.
This is not
But it is the general rules.
mentioned in the notification particularly that it will be applied retrospectively.
But by the said letter, it was stated that the particular officer
Particular
has
officer
to
only, not-
process the such applications, enclosing all relevant documents and send the proposal to Margherita for onward transmission to so and so. You do it, you send the proposal to,
After, no, we took on all the parts, and this annexure D is the reply.
annexure?
Annexure D of their petition, page number 18.
Oh, that is a reply to
regretted-
this, 8 and 12.
Yes. 8, no, 21 to 13, your lordship, the page number 18. That is after.
So that is dated 21/2/2013.
So when it is
That
of
your
the-
monetary, this is but otherwise by the agent. That monetary company claim has been rejected by the competent authority on belated ground.
related ground. And this.
What judgment you
notification-
want to refer?
And this notification is of general terms and condition. It is of
May I
general
interrupt,
nature.
sir? Actually, in the memorandum of 2010, there was no any issue of belated.
Yes, there was no issue was not.
And moreover, your
common
lordship, there is a difference between compassionate appointment and monetary compensation. That is why there is an or in between. She was more than 45 years probably, and therefore she did not claim compassionate appointment, and she claimed only monetary compensation, whatever is permissible under the memorandum.
But then that is not contemplated in the section.
Yes, sir.
In case the family dependent is above 45 years, she will be entitled only to, okay.
There is a provision here also. And moreover.
So she has opted for compensation.
Moreover, lordship, the notification of 2013 will not apply because that is a posterior notification, your lordship. And that cannot be given retrospective effect, your lordship. There are category of judgments. Retrospective, to give retrospective effect, there has to be a specific averment.
No, but then what he is saying is, after this 8/8/2012 letter, her case was sent to the authorities for approval. And then this is the reply to that.
They're rejected, but they what
That
they
is-
use,
that is
but
what
they use the
I'm
word.
submitting, your lordship. The order of 2012, notification of 2012 cannot be applied to reject the claim of the petitioner as submission of the claim belatedly. That cannot be applied because in the earlier memorandum, there was no any provision of submission of the rejection on ground of belated submission of claim. So, therefore, this cannot apply, your lordship.
But see, this before Devabroto case, there was another case, 94,
94.
which also
Mark-
provides for compassionate appointment, of course. But same analogy in compensation.
Because there is.
Our plea is
there is a
that we are,
memorandum
that
of-
are at
memorandum,
variance.
your lordship, agreement, and a post facto notification. This post facto notification cannot be applied.
They cannot be applied, yes.
And
Wait,
moreover,
you are quite aware that it
as per the memorandum of agreement, she is entitled to the monetary compensation. So they cannot, this, at page 18 of my petition, your lordship, they have rejected my claim on belated ground. And that belated ground was not there in a memorandum of understanding. So therefore, she is entitled to at least the monetary compensation. And that retrospective effect cannot be given to any application is there, your lordship. Judgment.
No, it's okay. Unless it is shown, it cannot be given. Okay, right. Heard, Mr. Doctor.
Give my name, your lordship.
Acha. Heard, Miss? P. Saha, learned counsel for the petitioner, and Mr.
AM doctor.
PM Doctor, learned standing
Senior
counsel for?
also
Yes,
led by Mr. MJ Ahmed.
Mr. MJ Ahmed, learned senior counsel, assisted by Mr.
AM doctor.
AM Doctor, learned counsel appearing for the respondents. By this application filed under Article 226 of the Constitution of India, the petitioner has prayed for payment of compensation, payment of monetary compensation to the petitioner in view of the memorandum of association, memorandum of agreement.
This one is the main book.
Yes, memorandum of agreement prepared.
This now the person.
No,
paid
it's the same one.
Yes. Same one. That was the extract only.
Acha, okay, take worry. Memorandum of in view of the, কি হলো? This is memorandum agreement prepared under what?
NCW, we say it as
Huh.
NCW and under chapter 9, your lordship.
Memorandum of
time-
agreement prepared by the respondent authorities.
or grant of such benefits.
The case of the petitioner is that her husband was working as a,
General must do, your lordship. Exclusive.
was
carry-
working in the Margherita what?
As explosive carrier, category 2.
Under Northeastern Coalfields, Coal India Limited at Margarita, your lordship.
Wait, where is that? He was working as, what did you say?
Para 4 lordship, you can see.
He was working as,
Explosive carrier,
Explosive carrier.
category 2, general must do.
Why I'm not getting in paragraph 4 explosive carrier? Is it there in paragraph 4?
Para 3 working, para 3 lordship, working as explosive carrier.
Acha, working as an explosive carrier.
Carrier.
CAT cat dash Roman 2 ডাঙৰকে Roman 2 at Borgolai
Colliery.
Colliery Borgolai comma Colliery 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 since 22/3/1983. The petitioner's further case is that her husband died in harness on 29/7/2007 when he had more than 8 years of service left. The petitioner had applied for compensation after the death of her husband. The petitioner applied for monetary compensation before the authorities concerned, as the same is allowed under the memorandum of agreement by clause 9.5.0
Of chapter 13.
of chapter 9
Chapter 9.
of chapter 9. Full stop. It is provided in the said provision that in case of death caused other than mine accident and medical unfitness, if the female dependent is below the age of 45 years, she will have the option to apply for compassionate appointment. And if the female dependent is above 45 years of age, she will be entitled only to monetary compensation. In view of the same, the petitioner applied for monetary compensation. However, her case was not accepted. No. She has made several applications, right?
The date may be crucial, your lordship. She
Ah.
applied on 25/2010.
Where is that? 12 letter I can get, but where is 2010?
But the letter was not there directly.
She applied for the monetary compensation first in the year 2010 and thereafter. What?
25.
2010.
25/2010.
Paragraph 12.
The representation of the petitioner was forwarded. No. An application regarding delay submission is required. Acha.
Earlier one.
Okay. In pursuant to the application made by the petitioner, the chief manager, Borgolai Colliery, intimated the petitioner that along with her application, she is required to submit another application showing the delay caused in applying for the said compensation.
Nothing came forward.
Then you have not written anything.
They have submitted, but a copy is not there.
To which the petitioner
Temporary.
had submitted an application. Anything in the pleadings why delay was caused?
No, nothing. That,
Petitioner further submits that as far as gratuity and other money and other retirement benefits, terminal benefits accrued to her deceased husband is concerned, that was paid to her. But compensation under the said MOA was not given. She, however, states that she got a letter dated 21/12/2013, 21/2/2013, by which the agent of Borgolai Colliery had informed her that monetary compensation as prayed for was rejected by the competent authority on belated ground. You are given terminal benefits, right?
yes, Your Honor.
That's right.
Benefits were given.
But in the petition you have written.
There,
After,
prayer was,
after this petition, they have.
no, we gave it in the year 2008 itself. And
You have received or you have
Received,
received,
received.
right?
8 bucks, you know.
The learned counsel for the petitioner submits that in the MOA, in the memorandum of agreement, it was not stated that the application for monetary compensation should be filed, should be submitted immediately on death of the related, on the death of the relative. And that it was only in the year 2012, more specifically in 8/8/2012, a letter was written by the chief manager that claims of monetary compensation after 6 months from the death of the employee will not be entertained. And that approval was sought for from the head office at Kolkata. Full stop. She submits that the said letter dated 8/8/2012 was much after her application before the authorities for monetary compensation, and that the said decision or the decision cannot be retrospectively applied. On the other hand, Mr. Datta, learned counsel, submits on the other hand, learned counsel for the respondent submits that providing monetary compensation is akin to giving compensatory compassionate appointment. And the same analogy is applicable in both the cases. Compassionate appointment is also given immediately after the death of the employee in order to save the family from financial vagaries. Similarly, monetary compensation is also provided to save the family therefrom. Like in compassionate appointment, delay in applying for the same is taken as an important factor for refusal. Similar is in the case of compensation amount. If there is delay in applying, the same requires rejection. And he submits that this is not a new development, but has been there since long. Para. It is seen that the petitioner has applied before the authorities for monetary compensation after almost 3 years, more specifically 2 years, 10 months from the death of her husband. But at the same time, it cannot be lost sight of the fact that petitioner is the wife of the deceased employee. And when her husband died, she was more than 45 years of age, and that she could not apply for compassionate employment, but applied for monetary compensation. The delay in filing for the same can be caused on genuine grounds. It can be a case that although she applied late, until today, more than 15 years, no.
19 years, Lord.
Then, till date, more than 19 years have elapsed from the death of her husband. The family may still be having financial constraints. Thus, this court finds it fit to direct the authorities in the Coal India, what? Authorities in the
Northeastern Coalfields, Coal India Limited.
Northeastern Coalfields, what?
Coal-
Borgolai Colliery.
That's a unit of the company. and
Northeastern Coalfields,
Coal India Limited.
Coal India Limited, to
Coal
examine
India-
the case of the petitioner in the light of the said facts, and instead of rejecting the case only on delay, can examine the financial conditions of the petitioner by any means, somehow, if they can find out by employing somebody, means. And if it is found,
Applied, nobody was there. Now the difficulty is that again the 20 years. And
and if it
authority
is
have-
found
None is applied.
that the petitioner has no means to sustain, has no proper means to sustain, the authorities in the Coal India Limited will consider paying the monetary compensation to the petitioner. The same be allowed with area benefits as well, if found eligible.
Yes,
If found eligible.
Riders in the other was.
These routers are there, we cannot do. The said exercise is to be completed within a period of 2 months from the date of receipt of this order. Petitioner to file a representation along with the copy of this order. At the earliest, petition is disposed of. Okay? They will see if they can, by employing some means or calling something. Petition is disposed of. Aru ki ase?
Item 37.
Yes, 37.
This is a case of
Hmm.
dismissal from service. Dismissal from service, madam.
Okay.
The petitioner is now 76 years of age.
How many, what is the age?
26 years.
76, okay.
But he had been dismissed from service after retirement, 6 years.
After retirement.
Now, which is brought under the some service pension rule 21. And moreover, my lord, his dismissal.
Why his disciplinary proceeding was started before retirement?
Yes, my only a so-called notice was issued
Before retirement.
for retirement.
He filed his reply.
This was issued in the year 1997.
Hmm.
And my lord, the SARS was framed on 2018 after I approached the honorable court.
Charge framed after retirement.
After retirement.
Hmm.
There is a delay. So, my lord,
Memo of charges was given after retirement. Memo of charges.
Yes, madam.
Then?
My lord, SARS sheet SOCOS was issued on 1997. My SARS was framed on 2018. Thereafter, they initiated a departmental proceeding. And finally, they have dismissed me without following the norms, madam. And the dismissal order, if not, just.
When did he retire?
He retired on 2012, my lord. 25/1/2012. If your lordship kindly use the dismissal order, dismissal order has been given effect from the date of absence with a retrospective effect, my lord.
Dismissal on what charge? Absent from duty.
Absent from duty.
Unauthorized absence.
Unauthorized absence.
Okay.
And lordship may kindly come the case number 114.
So that will affect his retirement benefits, right?
Only to affect this statutory benefits, this order has been passed. So kindly come to page 114.
114.
My lord. This is the order, my lord. The last paragraph, my lord. May I read this paragraph, my lord? Now, therefore, the government of Assam in health and family welfare hereby imposes the penalty of dismissal from service, which shall ordinarily be disqualification for future employment upon Dr. Arun Kumar Mohanto, the then Assistant Professor of Dermatology, Silchar College, as per rule.
Oh, doctor.
With effect from the date of absence from government service, 8/8/1994. And this order was passed on 20 March 2019.
Absence from service with effect from 94.
94, madam.
And this order was in 2019. So what happened? He does not go to the medical college and he has his private practice.
My lord, lordship will kindly see the SOCOS notice first, madam. That is a page.
That is a normal thing done by the doctors.
But this fact is different.
There are some doctors who even resigns from the government service. No, he has lucrative private practice.
But this case is different, madam.
Acha. Different?
Yes.
He is Dr. Arun Kumar Mohanto.
In this case, my lordship will find the SOCOS notice at page number 81.
Yes.
But this dated by 2nd June 1997. But this SOCOS notice was issued under Rule 7 of the Assam Service Disability Appeal Rule regarding his absence. And on this, the SOCOS, I gave a reply.
These are all perimeteria. In all the SOCOS, same things are repeated now.
But I gave my reply, that is at Annexure 8. Annexure 8.
So your charge is only one paragraph, right?
Only one paragraph.
Professor Dermatologist, you were remaining absent from duty since August without prior permission.
Yes.
Your negligence has immersed immense sufferings as well as students. Cyber, okay, then?
But I gave a reply at page number 54.
54 or 84?
54, madam.
54.
Annexure 8. Here I have made the reference. Reference, at the top, madam. Reference number so and so dated 2nd of June 1997. And I have.
Where is that reference? Oh, yes, huh? 97. What is this reference?
Reference to the SOCOS notice.
This is 97. Yes.
Reference I put here, madam. Here, madam, I have written, madam, that I beg to state that my wife so and so, pathology, GMC is suffering from brain tumor and is undergoing treatment at Apollo Hospital since 1995 under the above circumstances. I shall not be able to resume my duties at Silchar Medical College, and as such, I have decided to take voluntary retirement
as I have already completed 21 years of my service in Medical College of Assam and 1 year at the state dispensary, Walpara. My service record is big as suitable. But the fact is that, madam, he is at that point of time, his wife was suffering from brain tumor. Ultimately, she expired, madam. And at that point, madam, his children were minor. No one was there to look after them. So he said that since it should be a so-called notice, let me go on voluntary retirement. So madam, he applied for VRS, saying that since I have completed 21 years of age. Now, madam, after filing this, they were silent, madam. They become silent. Thereafter, madam, if a lordship
Departmental proceeding did not start.
but nothing started. Thereafter, madam, if your lordship see, madam, page 56, I wrote an application on 2009. Then
Page
again,
56.
2011. Then again on madam,
Application what? Why?
for granting me go on VRS. Then,
Then?
madam, these are the application, madam. Ultimately, his wife also expired, madam. And ultimately, I wrote the last representation at page number 65.
Okay.
Here I said that
Fact remains you have not applied for leave that time.
I'll show it.
It was not allowed.
Not allowed, madam. I'll show you, madam. Madam,
65 what?
this is
This
the
is
last.
the last,
I
okay.
filed before the authority. Either you go, let me go on PRS, or you give me the pensional benefits. Since I have retired from service, I retired on service from 2012, and I had this representation on last representation was on 2017.
So
After
he already retired in 2012.
12, madam.
Then what is VRS again?
Maybe.
You have retired in 2012.
Yes, madam. My date of retirement is 2012. But that was not considered. I was neither suspended nor terminated from service. Only that so-called notice was issued to me.
But you will be deemed under retirement, I think.
Yes, madam. So I prayed for the benefits.
Retirement benefits.
Different benefits, madam.
Okay.
That is, madam, the last representation, page 65.
But what is the, I don't know, tell me. So what is this prayer to accord VRS after retirement?
Madam, there is a provision to accord VRS ex post facto.
Oh, ex post facto, before his retirement. Then?
Yeah. Madam, after filing this representation, madam, even then also they was sitting silent, madam. Thereafter, madam, I approached this court. Yeah, I approached it, madam, before that, madam, that page 70. Page 70, madam. Page 70 is the letter put by the health department. Here regarding voluntary retirement of Dr. So-and-so, so-and-so. Here, lordship, if your lordship will find the list of supporting documents in reference of so-and-so during his service period at Silchar Medical College, Silchar. Number 1, can you see number 2? Send telegram stating extension of leave without mentioning period of leave. So, my lord, this is their record. They said that they have received telegram from me. Now, those days, my telegrams were.
Yes. He left SMC on 94's applying casual leave with station leave permission with effect from 8/8/94.
My lord.
Thereafter, for how many days was this leave granted?
Well, leave was initially granted for 1 week. Hereafter, since his wife expired, in order to look after his minor children at that point of time, he said that he let me go on VRS.
Oh, that was of course very late. That was in 2009 or what? That was in 2010.
No, madam.
After Shokos.
Shokos was on 97.
Oh.
And that first the reply to the Shokos was but on 1998.
February. Okay.
Thereafter, madam, I approached this honorable court. Lordship will find the first order at page 73 in WPC 1719 2017.
Page 73. Okay.
Madam. So, madam, I am before this honorable court since 2017, madam. So the first order was there, madam. this court ordered that in the meantime, the respondent are directed to pay the retirement benefits to the petitioner. Madam, this is at page 75, last line, madam. Nothing happened, my lord. Thereafter, my lord, this case, that case was disposed of with a direction on 6/11/2017.
With a direction?
Madam, kindly come to case number 79. Paragraph number 7. Para 7, madam, please, 79.
Okay, his pensionary benefit was processed.
Yeah, my lord, the standing council of the health department said that those his pensionary benefits are under process. So if he is entitled, so let him you pay the benefits. So, my lord, this case was disposed of with a time of 4 months. Hereafter, my lord, what happened, my lord? Suddenly, my lord, I received one impugn order at page 85.
85, okay.
Here, my lord, a letter was issued to me on 8 March 2018. They have appointed so and so as the inquiry officer and so as the presiding officer to my departmental proceeding of 1997. So, my lord, this was issued to me after I approached this honorable court, and the court ordered to verify my pensionary benefits.
Then they had started the disciplinary
Disciplinary
proceeding.
proceeding, madam. Now, Lordship will come to the next page, page 86, madam, the last paragraph. Here, the order was passed, madam. The last paragraph says, madam, therefore, taking in view of the above mentioned facts and pending departmental proceedings, a decision on the proposal of voluntary retirement benefit, voluntary retirement, pensionary benefit, etc., in respect of Dr. So and so can be taken only on completion of the departmental proceeding and will be based on its outcome. This was a view given by the government.
Okay.
Under this view, madam, they have started the DP again. Thereafter, madam, I again approached this honorable court, that is at case 89, 1932 of 2015. Here, my lord, if your lordship comes to page
Early conclusion of departmental inquiry.
page 91.
Okay, then
Page 91, para 6. In view of the above, this case is disposed of by directing early completion of the departmental inquiry expeditiously and preferably within 6 weeks from today. The running standing agent so and so should inform the petitioner or counsel about the revised data of hearing. It is
okay,
ordered.
then it was ordered to
Madam,
complete the,
Hereafter, my lord,
because he was retired by then.
my lord, my lord,
Then,
again, hereafter, my lord, lordship now may come to page number 10102.
inquiry report.
Inquiry report, my lord.
Okay.
So, my lord, here, this is of dated, my lord, 14/5/2018. Here it says, my lord, the charges were, my lord, Dr. So-and-so, while working as so-and-so, was absent from duty without.
It's okay, findings and conclusions that
Yes, my lord.
he had submitting casual leave for 5 days,
My lord.
could not attend duty
My lord.
as his wife was suffering,
My lord.
taken to Delhi, Chennai. He did not resume his failed to submit his leave application for his absence. Applications were submitted in Telegram. He was issued show cause. A reminder was issued. Failed to furnish a written reply, but written reply was given.
Now, my lord, thereafter, my lord.
Instead of furnishing reply for the unauthorized absence in response, prayed for voluntary retirement. Yeah, the delinquent remain absent without prior permission, never resumed office. Then?
Then, my lord, yes, my lord, the next page, my lord.
Huh?
After passing this order, my lord, the next page, my lord.
The department.
My lord, the second show cause notice.
This
This
is
is the
second show
show
cause.
cause notice, my lord, issued to me before imposing the penalty of dismissal. Here, the.
Asking for a reply to the inquiry report.
My lord, it says, my lord, as an unauthorized absence is a serious offense, the department may impose penalty of dismissal from service, which shall already be disqualification for the.
To submit your representation. Then?
Lordship may kindly mark the words dismissed has been used in the second show cause notice. But I've got the decision from the Honorable Supreme Court, madam, which says an event of our High Court. That means the disciplinary authority was predetermined to dismiss me, which is illegal, madam. I have to that effect. Madam.
May.
Madam. No, madam.
May. Word uses may.
May dismiss.
Of course, on the basis of inquiry report, he's saying.
Yes, madam. May impose an order of dismissal.
Then?
Then
You had filed your reply.
Reply.
Then?
I filed a long reply, madam.
Then it was imposed.
Then
What
it was
happened?
imposed.
Another case.
Then it was imposed, madam, but the order is at page number 113, annexure 29.
Yes. Huh.
The
This
last
is
paragraph-
the
last
impugn
paragraph,
order.
madam. The last paragraph of 114. It notifies already seen, madam.
Government of Assam and so hereby imposes a penalty. Okay.
Penalty with effect from the date of absence, madam, which is illegal, madam. That cannot be madam, from a prior date. Retrospectively cannot be done, madam. Hereafter, madam, I again approached the court, madam, in WPC, madam, 4930/2018. Then again, an interim order was passed, madam, at that point of time. The interim respondent are directed to pay the provisional pension and other to the petitioner. And nothing happened, madam. Then thereafter, madam, that repetition was disposed of with a direction.
But what this writ petition here, you have challenged the dismissal order.
Yes, madam.
But then no, this is impugn letter dated 21/6/2018. Shall remain stayed. What is this?
2018.
This is the 31/6. This is 20th of March 2019.
Yes, madam.
Here you have challenged something, some previous document, previous letter.
Madam.
Then what happened?
Thereafter, madam, this case was disposed of with a direction to file an appeal before the appellate authority. Since the dismissal was imposed. That your lawsuit will find that case number 133. 133, madam, last paragraph number 18. Therefore, if any appeal is preferred by the petitioner against the order letter so passed by the disciplinary authority, the complaint authority shall decide the same. Thereafter, madam, I filed the appeal at the next page. It's 134.
Then what is the decision of the appellate authority?
They have said nothing, madam. They have just read upon the earlier decisions. That order is at 152 page.
Yes.
Now, if you want to come to the last paragraph, number 156.
153.
156.
156, yes.
One careful perusal of the order, passed by the order for insurance for and also taking into account the written statement of the previous subject on the day of hearing on insurance, therefore is scrutinized of the available office record and
Why he is not entitled for voluntary retirement?
But they said that I was not, I have not completed 20 years at that point of time. They filed a affidavit.
Then this is the this is it.
But hereafter, my lord, during these processes, my lord, I paid an amount of rupees 74,519.
For what?
Last annexure. Even that amount has not been released till today.
This is why did you spend this amount?
They said that to release some GPF amount, this amount has to be paid. I paid, my lord, in the treasury. And this.
They deducted some amount.
Yes, my lord. Now
Hmm.
I paid, my lord. During the proceedings before this court, my lord, they started to initiate my pensionary benefit so that they will grant me. And after going to same, my lord, this amount was paid by me.
Hmm.
Even till today, my lord, they have not paid me this amount also, my lord.
Hmm?
Till today, my lord, they have not returned back my amount also, which was reflected in their dismissal order, appeal. However, department will take necessary step ordered by the application for final payment of PF.
Where is that?
56, last paragraph.
Hmm.
Even that amount has not paid to me.
No, this amount, why did you pay?
But they said that if you pay this amount, they will calculate the entire service record,
Ah.
then we will pay you. Now, madam, if your lordship come to some decisions of the court, madam,
Yes. Oh, এখন কি থাকি গল ৰে? এখন memorandum of agreement. এই আগৰ কেছটো দি দিবা দে। হা। Yes.
the first case is madam of the year 1991 for SCC.
Okay, so many judgments.
Madam,
At this.
just madam, 5 minutes, madam.
Ah.
Here, madam, in case number, paragraph number 8, madam, the issue is there.
No, what are these judgments about? Just tell me, you have already stated the facts. After retirement, this cannot be done.
My first judgment is regarding the issuance of the show-cause notice.
Hmm.
Whether a issuance of show-cause notice can be said that the departmental proceeding is pending. It says no. Only after serving the SAS memo, that is said to be that DP is pending. So in my case, madam, my show-cause notice was issued on 1997, and the memo was issued on 2018. So it's illegal, madam. The first
Oh, starting of disciplinary proceeding after retirement is illegal.
Madam, here it says, madam, the show-cause notice, issuance of a show-cause notice cannot be said that the departmental proceeding is pending.
Yes, that is a subtle position.
Yes, madam. This is
Only
the-
from memo of charge.
Yes, madam. This is the decision, first decision.
Then,
Lordship then come to the second decision. But I'll mark the paragraph, madam.
you mark the paragraphs here.
Madam, I'll mark. My second decision is dismissal would not be imposed after retirement. After retirement, the punishment of dismissal do not count, madam.
Hmm.
Does not arise. That is paragraph number 10.
Hmm.
The third decision, madam, 2005 6 SCC,
Hmm.
6
Hmm.
here it says that inordinate delay in the DP.
Hmm.
There is a 21 years, 23 years in completing the entire DP.
Hmm. Then,
Next is the second show-cause notice.
hmm.
But I marked one word, madam, that dismissal word. Here it says that in the second show-cause notice, the disciplinary authority cannot mention that what punishment is going to be imposed upon the incumbent.
Hmm.
And the third is madam, 2004 2 GLB 259. That is para 8, madam, E.
Hmm.
It's the issue and the answer is para 13. But here also same, madam, the same thing, madam. The dismissal word cannot be used in the second show-cause notice. If you use that word dismissal, that means you are predetermined to dismiss that person.
Hmm.
And the last, the last decision, 2014 12 SCC, 106. Here it says that dismissal cannot be retrospective, which has been done in my case, madam.
Cannot be retrospective.
Hello. No, this is the case, madam.
Hmm. Okay, Mr. Datta.
Lordship, normally it will be answered by the department.
Hmm.
We were only the approving authority.
So
FKC.
who
That-
appears for a department?
Health Department, Lordship. B. Gogoi. I have just informed him that he has left the court today.
But see, I have,
And
you
another-
tell him that tomorrow,
Yes, ma'am.
as a first item, I'll hear it and dispose it of.
Lordship.
Okay? So tomorrow.
Given the approval, Lordship.
He should not pray for time tomorrow because I've heard it finally.
Yes, yes,
Tell him that no adjournment.
yes.
He has to say whatever is required.
Lordship.
And tomorrow I'll dispose it of this matter. Okay, right? Heard Mr. S. SP Das, learned counsel for the petitioner. Hearing remained inconclusive. List it again tomorrow, that is 5th of June. $38, no more hearing now.
This matter, can you fix it? That matter, matter may not take much time, matter. As because.
But I have no stamina to hear
Yes,
anymore.
matter, not today, matter, some other day. Because I am submitting in that way because matter,
Okay.
court issue has been decided by division bench of the Delhi High Court, matter. After that, the respondent approached the apex court, matter. Apex court dismissed it.
As paid for by the learned counsels for the parties, list this matter on. When do you want?
If possible on 9th, matter.
9th of June.
Yes.
Okay, we'll give a try. 9th of June. Okay. 30, 40.
For
40.
exhibitions, it has come, Lordship, it has not come for hearing. So Lordship, a kindly short date may be fixed, if possible.
Otherwise ready for hearing.
Yes, ready for it.
As prayed for by the learned counsels for the parties, list this matter on when? 19th.
Next week, any day.
16th. Okay. List this matter on 16th of June. No, last week we will not keep hearing matters.
16th, Lordship. Lordship, he is also suffering last 4 years.
Lordship already has fixed, I already have obtained time and I have to go through the records, Lordship. Or after the vacation.
Lord, before the vacation, if possible, Lordship.
Okay. 23, 23rd of June. 23rd of June. We'll give a try, provided she finish looking.
Lordship.
Okay.
Lordship, I am appealing item 39, my colleague is from there. Matter is for pensionary benefits, my lord. They are not denying our claims, my lord. In fact, they are with instruction that they are paying some amount, my lord.
Already file is in process and they'll be, within next week, they'll be making some payment. Let it come after 2 weeks, my lord.
After 1 week, my lord, because
Okay. As prayed for by the learned counsels for the
They-
parties, list this matter on 18th of June.
my lord.
Master.
Yeah.
Okay. Ouch.